Well, hello everybody, and welcome back to Raw Law Unfiltered with your host, the DUI Guy Plus. Today, we have a treat of all treats for you all. Today, we are finally going to go over the Writ of Prohibition. We're going to go over what it means. We're going to go over what has happened. And we're going to cover the writ itself right here, right now on this channel. So buckle up, Buttercup. Buckle up, Grudge Judge. And hashtag justice for the Hales. This is still developing. As you all know, I wanted to go over it yesterday. But it wasn't ready. And as my sources tell me, excuse me, as my sources tell me, this was not filed until literally the very last minute this morning. Okay. And for obvious reasons. I mean, look, at the beginning, you have to understand this is a 50-page writ, okay, a 50-page motion that essentially that the way it works is when you request a judge to get off a case and they refuse continuously, and 3 times Jeremy's lawyers requested the judge to step off the case, and 3 times he refused to step off the case. Finally, they said, okay, you know what? We're done asking you because clearly you're not listening. You're ignoring our pleas for relief. Excuse me. Ignoring our pleas for relief. I had some lunch meat stuck in my teeth there. I apologize. The prayers for relief can only come from the higher ups, the Court of Appeals. Okay. And that is why, as you can see on the very front page already, petition for writ of prohibition, look at the title at the top. It does not say Levy County Circuit Court, Judge DeThomasis. No. That's it. We're done with you. We are done with you, Judge DeThomasis. We are now asking the Court of Appeals of the state of Florida, 1st District, right there at the top, right there on your screen. We're asking you to remove Judge DeThomasis because he refuses to remove himself. He refuses to listen. He's not cooperating. He's not listening. So please help us. Please help us because he's refusing to listen. So that's what a writ of prohibition is in a nutshell in this case. Now, writs of prohibition can be used for multiple different avenues. But in this case, the only thing we really care about is the Haleses filed, their lawyers filed on their behalf, on Jeremy's behalf. There he is, Jeremy Hales, petitioner. Lynette Preston is now the respondent. Notice how all of a sudden these 2 names are flipped. Why is that? Because Jeremy Hales is now petitioning the court, this court, Florida's 1st District Court of Appeals, to remove Judge DeThomasis in the lower court, the circuit court, the district court, circuit court of Levy County. Okay. And a different judge now, or panel of judges, is going to review this motion, they'll review this writ, and rule on it. Now, like I said, this writ was literally filed at 5:55 this morning. And the judge is a stickler for rules, and I saw the timestamp like they started the process at 5:55, his lawyers did, and the timestamp on the 1st District Court of Appeals didn't even have a case number this morning. Now there's a case number finally assigned to them. It's not like finalized until 6 a.m. in like 13 seconds, right? So it took them about 5 minutes to go through the process, fill in all the paperwork, check in all the boxes, and et cetera, et cetera. And let me tell you, I was, for a moment myself, I was like, is Judge DeThomasis going to be like, nope, you're 13 seconds late, we're holding trial? Because I was like, this is a man that's actually capable of doing that. But I don't think he's that insane. He's insane, but he's apparently not that insane. And thank goodness, because his lawyers, my sources tell me, did not get any sleep at all. They were working literally all night, and they just finally went to bed at like 6 a.m. this morning when they filed this. After they filed this, they went to bed. So thank goodness. Thank goodness. It's already 3:00 local time. Obviously, there's no court. There's no hearing. The judge seemed to have accepted it, and thank God. We got a Megan the writer, Megan Fox writer raid. Welcome, everybody. Welcome. Hello. And you guys like feathers? Do you guys like feathers? I have a feather. I got it at the Vatican when I was visiting Rome. And it comes with a cute little ink box, and you can choose which color ink you want. And I chose this color ink. I don't know if it will refocus. There we go. Come on, camera. It doesn't want to focus on it. But anyway, it says Inchiostro blue. That's the type of ink it is. To me, that kind of looks black. It might be kind of like a dark blue, but kind of comes in a set like this, and I think it's pretty cool. You can get these all across Europe. I got mine at the Vatican because I thought it was cool when I was in Rome. But anyway, and now it's very apt because we have Mark Feather, and I may one day write a letter using that feather, using Mark Feather to write my letter. It is very, very. I can't rhyme. It's to me. I've been literally go since 6 a.m. and I slept like 3 hours myself, so my brain may not be as sharp today. So please excuse me if the jokes are very dad-like and dad humor, because that's probably all I'm going to be able to muster today. And you can probably tell that I'm so drained. It's been a hell of a week, and trust me when I say this, I regret nothing. This is the wildest thing I have been a part of since the Johnny Depp trial. And I am happy to be a part of it because we are helping people and we are assisting in the administration of justice. So if I lose a few hours of sleep for it, in the past week and a half, couple of weeks, it's okay. I'm going to be all right. I have a vacation around the corner. The girlfriend and I are going to be going down to an undisclosed location in Florida. And we're going to be on a beach come next Thursday, so I can't complain too much. To the contrary, it's actually going to be a good final relief, right? Like all this build up to a vacation. So I'm very excited. All right, let's go. Let's go through this. We have a lot to cover. Welcome everyone who's joining from Megan's channel. In the District Court of Appeals of the State of Florida, 1st District, case number 1D24-, we don't know yet at this juncture. Now, I can tell you that I do know now because I have the receipt, which we're going to go over as well. At the end of this, if I forget, remind me, please. Anybody who's in the chat right now, we have another thing that has been filed literally 10, 15 minutes ago. And I have a copy of it. And we're going to share it right here on stream, on screen, after we're done with this. So that's another sneak peek. That's another preview that I don't know if anybody else has a copy of it yet. Okay. So we're going to go over that at the end of this petition, because this petition is, just brace yourselves. Just brace yourselves. So again, Jeremy Hales, he's now flipped for the moment. It will flip back once the court either grants or denies this petition. Okay. Shochet Law Group, Doreen Inkeles. I think I finally learned how to pronounce her name correctly. Petition for a writ of prohibition. So they're asking the Court of Appeals for the 1st District to remove Judge DeThomasis on Jeremy Hales' case. Okay. There she is. Megan Fox, raid incoming. Thank you so much. Thank you so much, Megan. You guys are freaking awesome. We got another raid. I guess we got at least one. I saw there we go. Everybody's here. So pursuant to Florida Rules of Appellate Procedure 9.1, petitioner Jeremy Hales, in the future they're just going to use Hales, petitions the First District of Appeal for a writ of prohibition prohibiting the Honorable Craig C. DeThomasis, Circuit Court Judge of the 8th Judicial Circuit, Levy County, Florida, from presiding over proceedings in the case number. This is Lynette's petition. This petition follows Judge DeThomas's orders denying Hales' second and third motions to disqualify for bias rendered on February 14th, 2024 and February 28th, 2024. Okay, so that's just a quick preview. So the Court of Appeals, when they receive these petitions, when they receive these motions, when they receive these appeals, they get so many. They get so many things. It's nice to have one succinct paragraph because that way the Court of Appeals can kind of look at it and be like, okay, what is this about? And they read one paragraph. Oh, this issue is going to take a long time to research. Just like you and I, they procrastinate. They put it to the bottom of the pile. Let's look at this one. Oh, this is simple and easy. Let's get this done real quick and get it bing, bang, boom out of the gate. Court of Appeals judges are no different than you or I. So this little paragraph right here gives them guidance as to what this is about, how long it's approximately going to take them to rule on, how difficult it is, how much time it's going to take, and so on. Now, the basis for invoking jurisdiction, we always start with the law. Unlike Judge DeThomasis, we start with the law. The law says petitioner invokes this court's jurisdiction. This is, again, this court. Where are we? We're in the Court of Appeals. So that's it. DeThomasis, at least for the time being, is frozen in time. Have you seen the thumbnail for this video? If you haven't seen the thumbnail, kudos to my thumbnail maker. That is one of the most gorgeous thumbnails I have ever seen in my entire life that he has ever made. He took Judge DeThomasis and turned him into a block of ice, or like he turned him ice cold. He drew like this icy beard over him, and he looks like he's speaking and he's like frozen in time. It's just like, it's like really, really good. It's amazing. And that's exactly what's happening. Judge DeThomasis right now is frozen in ice. Now, here's the problem. And by the way, I've been reading some of your comments, and I would like to correct myself. Thanks to you all. You guys have helped me understand this because when I went over live, it just didn't really click. We do have 5, not 1, not 2, 1, 2, 3, 4, 5. I plead the fifth. No, we have 5 constitutional violations here. We have 5 of them. We have a First Amendment. Jeremy Hale has been denied his ability to share the court proceedings on YouTube, right? We covered that. Number 2, he's not allowed to have guns while this petition is pending since December 4th. Number 3, this is the one I left out. He is his 4th Amendment right, and I updated the description below for this one. His 4th Amendment right is being impeded because the easement, I forgot about the easement. The easement that allows him to enter the property. So there are 2 ways to get to his property. One is less dangerous. The other is more dangerous. People die on the more dangerous road. Well, the less dangerous road, where people don't die as often or rarely or ever, has been blocked off by judge's order because it's close to the property of the Preston, Lynette Preston's property. So Judge DeThomasis did deprive Jeremy Hale of his 4th Amendment right by seizing his land. So not only just compensation, forget just compensation, he seized his land, metaphorically speaking, without any due process of law, which bleeds me into number 5 and 6, right? So due process of law has been deprived. And number 6, he's been deprived of a speedy trial. So speedy trial, due process of law, seizure of land, taken away his right to bear arms, and forbade him from speaking and will hold him responsible for other people's speech. That is a staggering. That is confirmed, right? That's it right here. You heard it here first, folks. 5 out of 10 amendments the Judge DeThomasis violated in this case. That's it. You only need 1 to disqualify him. Here we have 5. And that's it. That's right, Book Hermit. And that's where I think my legal brain was. When you have so much, it is so hard to keep your head on straight because you're like, oh, come on. There's no way he violated that one also. And then you're like, well, shit, he did violate that one also. It's terrifying. But let's keep going, okay? Let's keep going. And I'm talking just about the Bill of Rights. I know you guys are talking about what about the 10th Amendment? Excuse me, the 10th Amendment. The 14th Amendment is it applies to the states. I mean, of course, that's been violated. But 5 out of 10 to me is more than enough. Is more than enough. Do we really need to go further? It would be embarrassing if we can nail him on, like, remember I made that joke on I think I was on, whose channel was I on? I think it was on Tug's channel. I was like, we had the Haleses on a few days ago. And I was like, it'd be really funny if Judge DeThomasis literally just went through the amendments and was like, all right, which one do we have next? They took away your First Amendment, like a checklist. I took away your First Amendment right, check mark. I took away your Second Amendment right, check mark. Third Amendment, quartering of troops. Quartering of troops. Mr. Hale, I order you to quarter troops in your home. If you do not quarter troops in your home by the end of the day, 5 p.m. Eastern, it is now 3:15 Eastern p.m. If you do not quarter troops by the end of the day, sir, you're going to be held in contempt of court. All right, what's next? Fourth Amendment, check mark. Fifth Amendment, check mark. Sixth Amendment, check mark. Seventh Amendment, right to a jury trial in civil cases. This is not a civil case. This is not a civil case. Mr. Hale, I order you to institute proceedings in a civil case, and I'm going to be the judge on it, and I'm going to deny your right to a jury trial. All right. Number 7 is checked. 8, lock him up right now. Unusual punishment. Check mark. He can literally go through and violate him on every single one of our amendments. And that is that is just staggering. That is just absolutely staggering. And I know I'm making a joke of it because I've never seen such egregious conduct. And when the conduct becomes so egregious to the level of just complete madness, complete and utter insanity, it defies the laws of humanity. Forget the law. I mean, the law has been violated so much. The law is literally looking at you, back at you, like bare naked, saying, like, what do you want me to do? I've been violated in every orifice. Sorry for the graphic image, but that's exactly what the Constitution has completely eroded in Judge DeThomas's courtroom. It's been, the Constitution has been violated personally by Judge DeThomasis in his courtroom. So if he did that to Jeremy Hales, how many more people did he do that to? How many more people has he violated, or their rights, or taken away things that belong to them? It's terrifying to think about. It's terrifying. All right. So we are now, again, like I said, we are in the Court of Appeals, the Florida Court of Appeals. We are no longer in Judge DeThomas's courtroom. So petitioner invokes this court's jurisdiction under Article 5, Section 4B3, Florida Constitution and Florida Appellate Rules. Prohibition is the proper remedy to test the validity of an order denying a motion to disqualify a judge. This is our last remaining remedy. Judge refuses to step down. Therefore, we need your help. Help us remove him from this case. This is not a removal from the bench. I know you guys are going to have super chats and questions about this later, which we'll get to at the end of the video. By the way, don't forget to like this video, comment below, subscribe to the channel. Holy hell, there's already 7,000 of you in here, and it's not even 5 p.m. yet. Because buckle up, folks. Hashtag buckle up. This is about to get really fun. So again, this is the way you disqualify a judge. Writ of prohibition. Simple. This court, the Court of Appeals, has jurisdiction to review the denial of a motion to disqualify a judge for bias pursuant to this section, Bundy, Barnett, Padovano. Like, they're listing all these cases. Now, the statement of the facts. Judges, Court of Appeals, here's what happened to Jeremy Hales. Jeremy Hales files this petition for writ of prohibition, seeks disqualification of Circuit Court Judge Craig DeThomasis, Levy County, Florida. The statement of procedural facts with references to the appendix is set forth below. The merits ultimately involve the intersection of First Amendment rights to free speech and Florida's cyberstalking statute. And again, notice how they did not list the Fourth and the Fifth Amendment and the Second Amendment violation and the Sixth Amendment violation, because they want to keep it simple, stupid. When you appeal something like this, you want a KISS. Keep it simple, stupid. For brevity's sake, you don't want to go too deep. You focus on the number one biggest issue, That's the First Amendment issue, right to free speech, and cyberstalking statute, which is Lynette's initial petition, which she filed under. It's the clashing of the two. Now, Hales and his fiance operate a popular YouTube channel program called What the Hales. It is a video journal of their lives with much interest generated in their treasure hunting experiences, as well as their promotional events that involve extensive charitable giving. They have a national, international viewership of approximately 700,000 people. And by the way, that is not even an accurate number because, as we all know, subscribers, that's just their subscriber base. I mean, they have over 300 million views. But maybe they don't want to point that out too much to the Court of Appeals because, I don't know, for one reason or another, this is a strategic approach, and I trust his lawyers. They also have a stalker fan who, that's an understatement of the century, a stalker fan who moved across the street from him in a tiny town population, about 100 people in Florida. This petition for a writ of prohibition arises from the trial court's denial of 3 motions filed by Jeremy Hales to disqualify Circuit Judge Craig DeThomasis for bias. On February 28, 2024, the judge entered a 3-page, single-spaced order denying Hales' third sworn motion to disqualify. And it's now all of these bracketed numbers that you're going to see, these are all references to the record. So the Court of Appeals can follow along if they want to look at something just to confirm, like, oh, what is this 3-page order? I want to see this. They have easy access to it. It's on, A3 and A6. On Valentine's Day, the judge entered a 5-page, single-space order denying Hales' second sworn motion to disqualify. Because the judge's Valentine's Day order denying Hales' second motion to disqualify was wordy, excessive, and ran afoul of Rule 2.330 of the Florida Rules of General Practice and Judicial Administration, the order of Valentine's Day became the basis for Hales' third disqualification motion. Hales' first motion to disqualify Judge DeThomasis was filed on December 21st, 2023, as a result of Judge DeThomas's excessive participation at hearing on November 29th, 2023, in which he, among other things, that's Latin inter alia, among other things, conducted the direct examination of the petitioner in the lower tribunal, that is Preston. The judge entered an order denying the first disqualification motion on December 26, 2023. Documentary evidence in this record is included in the appendix, and references thereto are denoted as such. So, as we already predicted, the electronic recordings of the hearings from the 8th Judicial Circuit, including January 23rd, will be submitted by supplemental record. Quotations taken from the recordings include timestamps indicated in brackets the number of minutes and seconds into the proceedings a given comment was made. For example, this is what it's going to look like. Transcripts have been ordered and are being typed. Now, one of you may sit there and ask, well, why didn't his lawyers do this ahead of time? Why are they saying, like, this will be submitted and this will be submitted, but here's the motion? I'll tell you why. Because in there, the thing that we went over yesterday, the motion to stay proceedings, the motion to freeze proceedings before a writ is filed, the request was to allow Doreen and Randy, Jeremy's lawyers, to file, a week from now. All they asked for is 7 days. Judge, we need 7 days. Just freeze the proceedings. We need 7 days to get this written. You know what the judge said? To nobody's surprise, he said, I'm going to give you 1 day. He said, I'm going to give you 1 day. I'm giving you 1 day. Take it or leave it. That's what he did. 1 day. So this motion was very, very rushed. So anytime, God forbid, if you see any like typographical errors or any, maybe stylistic errors, please give the lawyers credit, because instead of having 168 hours to work on it plus sleep, they literally had like 30 hours to work on it. And I don't think they slept. My sources tell me that the first time they went to sleep was literally this morning after this motion was submitted. That's what the judge is. He's a tyrant and an absolute dictator. And he deserves to be removed, not just from this case, but from the bench completely. Pursuant to Rule 9.1 Florida Rules of Appellate Procedure, Jeremy Hales seeks a writ of prohibition prohibiting Judge Craig DeThomasis from further participating in Levy County Circuit Court case number such and such. That's Lynette's petition. Additionally, Hales requests issuance of an order to show cause. Now, this is interesting. So that a stay of trial proceedings may be effectuated pending disposition on the merits. The final hearing that was set for March 1, 2024, today, has been continued with a date to be determined. There is no date on the record. The extension on the temporary injunction against Jeremy, depriving him of his rights, is in limbo. He's literally in purgatory. He's literally sitting in purgatory right now. He's in limbo. He's in purgatory. This is insane. This is completely insane. Good cause exists for this court to issue show cause order because of the intolerable adversarial atmosphere Judge DeThomasis has engendered as set forth in the petition for the writ of prohibition. The final hearing that was set has been continued with a date to be determined. I mean, that is just terrifying. A judge can strip a man of his rights. Well, actually, that was a good one. Jeremy and George need our prayers. No kidding. I accidentally highlighted it, and apparently my brain wanted to highlight it because that was not an accident. I agree with you, Linda. They are completely deprived of their rights by this rogue judge who refuses to step down. And now the lawyers are asking the Court of Appeals to remove him from the bench, from this case. Again, anytime I refer to removal in this video, we are solely talking about removal of Judge Craig Constantine DeThomasis from this case. Okay? We are not removing him from the judiciary. We're not trying to exclude him from the bench in this video. Okay, those were some previous videos. They're on my channel. They're in the description below as to why he should be removed from the bench permanently. But right now, we're only talking about why he should be removed from this case. Okay, just so that we're all honed in and you understand what's going on. Okay, all right, let's keep going. So the standard of review, again, we always start with the law. Unlike Craig DeThomas's, we always start with the law. Allegations in a motion to disqualify are reviewed de novo, anew, as to legal sufficiency. That's Peterson. The standard for reviewing the legal sufficiency of a motion to disqualify is whether the facts alleged, which must be assumed to be true, which Craig DeThomasis refuses due to his egotistical and narcissistic nature to assume to be true, and he just ignores everything and just rules, I'm staying on the case no matter what, would cause the movement to have a well-founded fear that he or she will not receive a fair trial at the hands of that judge. That's the case of Wall. Now, the deprivation of procedural due process claim is reviewed de novo. Again, de novo is Latin for anew. So they don't review it for like abuse of discretion. They review it as if the case is before them under the law. And that's Pena versus Rodriguez. Pena probably, I don't know, maybe. Now here comes the argument. Argument number one. Judge DeThomas's lengthy, self-indulgent orders denying motions to disqualify are themselves independent bases for disqualification. When a trial court looks beyond the legal sufficiency of a motion to disqualify for bias and attempts to refute the allegations, it exceeds the proper scope of inquiry, and disqualification is required on that basis alone. Let me read that again of how important it is. The lawyers are leading with the most important argument. This is exactly what you're supposed to do. This is how you write these things. You poke at the most painful spot. You know those movie scenes where there's like somebody with a gunshot wound and they're trying to get him to talk. What do? They put their finger and they insert it like into the wound. Remember, I think it was like an Inglourious Bastards. I can think that's the one movie that comes to mind when what's her name? The female character is laying there on the veterinarian's table, and they're trying to get her to admit, like, who did you talk to? What happened? Why are our men dead? Spoiler alert. If you haven't seen that movie, it's like 15 years old, but whatever. When he pokes her you want to poke that bullet hole. Poke it where it hurts the most first, and then you talk about all the other stuff. Okay? So it exceeds when a trial court looks beyond the legal sufficiency of a motion to disqualify. So rather than just looking at it from a legal standpoint, but attempts to argue and refute the allegations, that's it. That's all that's required. On that basis alone, that's enough to disqualify a judge. Court of Appeals, please help us. Regardless of the correctness of the denial of the motion is legally insufficient. And there's case law on that issue. That's Bundy, Blalock, in Manuel, and the court even noted in Manuel versus Estate of Manuel, our disqualification rule, which limits the trial judge to a bare determination of legal sufficiency, was expressly designed to prevent what occurred in this case, the creation of an intolerable adversarial atmosphere between the trial judge and the litigant. In theory, again, as a lawyer, looking at this, if I saw this, if I was a judge and I saw this come before my desk, you can probably, like, based on everything I know, stop the motion right there. And I'm like, yeah, I saw what happened. It's intolerable. It's adversarial. There's precedent on the issue. We call it stare decisis. That's another Latin word you don't need to know, but I'm going to say it anyway because I know it. And so I want to share it with you. Stare decisis, literally right here. Prior cases say intolerable adversarial atmospheres between the trial judge and the litigant are expressly designed to prevent what occurred in this case. That's what the rule is. The disqualification rule is designed for. Get him off our case, please. Judge DeThomasis, however, seems to believe that in 2024, that a trial court may, quote unquote, comment on the status of the record when denying a motion to disqualify for bias, which he did, and the record is cited. That, however, has never been the law in the first district where the Levy County Courthouse lies. Nonetheless, paragraph 4 of Judge's February 28th, so 2 days ago, order denying the Hales' third disqualification motion stated in relevant part. We went over this yesterday, I believe, or maybe it was Wednesday. I can't remember. In this court's prior order, it's all in the same playlist, by the way. If you're not yet subscribed, don't forget to like this video, comment below, subscribe to the channel, join on as a member if you're so inclined. Don't forget to hit that notification bell. Also, if you want to ask a question, you may super chat it in the box below. And I'm going to be reading all those super chats later on. And there's a playlist, a What the Hell's playlist on this channel, and it is growing by the day. I think we're almost up to double digits. We're almost up to 10 videos talking about the judge, talking about the Haleses. I interviewed them, et cetera, et cetera. We had Megan on the channel, and it has been really, really fun learning about all this and attacking this judge because he needs to be removed, not just from this case, but permanently. In this court's prior order issued on February 14th, 2024, under subsection 7A through F, the court explained the relevant and material status of the record, not by taking issue with averments contained in the motion under review, but rather by identifying that it was true that there were several transgressions from applicable law and procedure engaged in by counsel throughout the proceedings, which were then addressed by the court as they arose. Notice how they're underlying, the lawyers are making it a point. Look at what the judge said. These are the judge's words. These are the judge's own words. So hashtag buckle up, Buttercup, because it is coming. The Court of Appeals is coming after you, Judge DeThomasis. That's it. That is it. With paragraph 4 of his order on February 28th, Judge DeThomasis is effectively telling us, including this court, that Judge DeThomasis doesn't have to follow the rules. That's what he's saying. That's what the lawyers are saying, and that's what we heard him say. Rule 2.330 is the operative and controlling rule for disqualification matters. If any motion is legally insufficient, an order denying the motion shall immediately be entered. No other reason for denial shall be stated, and an order of denial shall not take issue with the motion. Look at that. And he's violated all those rules. He's just ignoring the law. Again, seems to be a pattern with this man, only this time we got him. This time we actually got him by his arrogance and his bias and prejudice towards Mark Feather. Mark Feather, 15 minutes, 15 minutes, Mark Feather. Just because of that alone would be enough. But now he's also going after Doreen. He's going after Randy. He's going after Jeremy. It's impossible for him to remain on this case. So if any motion is legally insufficient, all you need is just entering a denying motion. Oh, I just deny. But he went on, and by his own arrogance, he's just adding more nails to his coffin. And now Jeremy's lawyers are highlighting that in their writ of prohibition. Again, for those of you just joining us, the writ of prohibition in simple language, in this case, it is basically the following. Hey, Court of Appeals of Florida, we have a judge here who is not doing what he's supposed to do. He's not following the law. He's creating very adversarial atmosphere in his courtroom. Can you please help us? We need you to remove him. That's what this writ means. That is it in simple terms. Court of Appeals, please help remove him. He refuses to go. That's it. That's it in one sentence. And an order of denial shall not take issue with the motion. And he is taking constant issue with the motion, and it's in the rules. He's ignoring the rules. Judge DeThomasis is continuously ignoring the rules. It says, no other reason for denial shall be stated, as we just read. And look at paragraphs 7A through F of Judge DeThomas's February 14th order denying disqualification in this case. It says, it is true that on January 23rd, this court did make an oral pronouncement. I'm not going to read it in his voice, but listen for the arrogance. Listen for the confrontational tone. Listen for the constant bombardment that he does. Because we read this on the 5-hour stream that we had on last Sunday. And it's on the channel. Like I said, it's in the playlist. You can check it out. What the hell is this playlist? Just listen to this language. Once again, this is just paragraph 7, A through F. Judge DeThomasis writes, it is true that on January 23rd, this court did make oral pronouncements that were adverse to positions being advanced by the respondent through his counsel regarding the posture of the case and the intervening developments. Some are contrary to law. He just violated Rule 2.330. Boom. That again precipitated another request for a continuance. These included, but were not limited to, the following on the record proceedings. A, on November 29th, 2023, in response to the court inquiring whether he, the respondent, would be available to reconvene the following date at 9 a.m. to complete the hearing, co-counsel for the respondent, Mark Feather, 15-minute Mark Feather, represented to the court the following. No, Your Honor. Mr. Hales is having to address matters in Ohio court related to his situation. He has to be there tomorrow morning. Based on such representation, the court continued the matter, which at that time did not have any temporary injunction relief in place, to reconvene on December 6, 2023. B, back to the judge. During the proceedings held on December 6, 2023, the court learned, to their own chagrin, from co-counsel Randall Shochet and the respondent himself, Jeremy Hales, on the record, that the respondent did not actually need to appear in Ohio on November 30th and that he only needed to sign documents. That he only needed his pen and paper. Why did he need to go to Ohio? The court is displeased with, you shall refer to me as Your Majesty and not Your Honor anymore. Needed to sign documents 2 days later with his Ohio attorney. And as a direct result, it is true, as alleged in the motion under review, that the court, meaning me, did admonish counsel for the lack of candor. You lied to me. Lack of candor means you lied. Lack of candor towards this tribunal, meaning me. And such behavior was again addressed on January 23rd, 2024, as the court considered the totality of the circumstances in the case when deliberating on additional motions being adjudicated. Violation after violation after violation of 2.330. Further, C, despite the clear dictates of the Florida Supreme Court in Administrative Order AOSC 11-22 and the 8th Judicial Administrative Order, Circuit Administrative Order 1.14 version 2, there was undisputed evidence that confirmed confirmed attorney for Jeremy Hale, Mark Feather, 15-minute Mark Feather, despite having previously signed an attestation that he was aware of the admonition regarding the prohibition against the dissemination of unredacted copies of court proceedings, did disseminate an unredacted copy of the 11/29/23 court proceedings, and he was the only person to have requested an unredacted copy of his client, the respondent, and then to broadcast the unredacted copy on his social media platform. It is true that, as alleged in the motion under the review, as the counsel was admonished on 1/23/24 for such behavior as it was contrary to the dictates of the Florida Supreme Court and the Chief Justice of the 8th Judicial Circuit. The Florida Supreme Court issued AOC 1/11/23 on July 20th, 2011, said order attached and incorporated revised standards of operation and the best practices in the part to standardize court operations while continuing to protect from inappropriate release any confidential information that may be captured on electronic recordings. The Florida Supreme Court further directed each judicial circuit to codify protocols for producing copies of audio and video recordings, and further, not only that, the AOSC 11-22 section XVI A2 states the following: that copies of video audio recordings may be made available to attorneys of record, parties to a case, and self-represented litigants like Mark Feather, upon request, so long as an acknowledgement is provided with a copy of the state's confidential information may be contained in the recording. Further, dissemination of confidential information contained in the recording is prohibited. In violation of the prohibition against the dissemination may subject the requester to an action of contempt of court. In accord with the Florida Supreme Court's directive according to the released video audio recordings of court proceedings, the 8th Judicial Circuit codified its protocols for producing copies of audio video recordings in Administrative Order number 1.14 version 2, which states in relevant part as follows: copies of electronically recorded court proceedings shall be provided upon request. The requesting party shall be required to complete and sign a written transcript, audio video recording, CD request form, and prohibition against dissemination to obtain audio recordings. It is true that on January 23rd, 2024, the court did express dissatisfaction and admonished counsel and Mark Feather and the respondent for broadcasting the unredacted audio video recordings on the YouTube, despite the clear dictates of the Chief Justice to the Florida Supreme Court and the Chief Justice of the 8th Judicial Circuit. Number E. Further, on that same day, January 23rd, 2024, the court also learned that attorney Randall Shochet conducted a video deposition. Where was Mark Feather? Of the petitioner without complying with the Florida Rules of Civil Procedure 12.310 before, and despite having conducted said deposition in contravention of the applicable rule, the respondent had published and publicly broadcast and deposition of his social media site. The YouTube is back. The YouTubes. It is true that the court expressed dissatisfaction with such a violation and denied counsel's ability to play the video deposition because it was on YouTube and was taken down in non-compliance with the rules of civil procedure. It is true, as alleged in the motion under the review, that on January 23rd, 2024, the court also commented upon a proffered memorandum of law that was submitted and presented to the court by attorney Randall Shochet. Why was it not Mark Feather? I wanted Mark Feather. Submitted on January 22nd, 2024, see docket entry 97, that in the court's view unnecessarily, unprofessionally, and gratuitously criticized opposing counsel for filing a limited notice of appearance for the purpose of advancing argument to continue on behalf of the petitioner. As counsel averred, he had a conflict and could not and would not be able to serve as counsel in the event that the court did not change the next scheduled hearing date from January 26th date previously scheduled. As the record would indicate, the court did admonish respondent's counsel, you mother marker Feather, for presenting such an argument in such a manner as the court would remark as reminded Mr. Shochet that he, Mr. Shochet, why not Mark Feather, filed his own notice of appearance 24 hours prior to an already scheduled hearing date scheduled on 12/6/23, and as a result, he advanced argument that he could not possibly be prepared and thus required a continuance, which was granted. The rhetorical and condescending language advanced in a filing labeled as memorandum of law, which was not a memorandum of law at all. It described as wholly unacceptable behavior of opposing counsel like Mark Feather and YouTube, which was in fact the same behavior previously exhibited by respondents' counsel. Okay, I think I gave it enough of a tone. I think you guys get the idea. I've tried to make it sound as adversarial as DeThomasis probably intended for it to be. All right. Back to the lawyers. So to be clear, in paragraphs 7a through f that we just read of the order, Judge DeThomasis criticizes Hale's attorney, mostly Feather, for violating administrative rules of court. Again, but the fact that the Judge DeThomasis included that information on administrative rule violations in his order denying a disqualification motion, which is not to give any other reason for the denial, would suggest that Judge DeThomasis himself violated an administrative rule in the course of trying to humiliate someone for violating an administrative rule. You see what he's doing, the lawyer for Jeremy? He's pointing out exactly all the rules that the judge is violating. And his order itself that we just read, I think as accurately as one possibly could, he's attacking a lawyer that's not even there to defend himself, and he's humiliating someone for violating a basic administrative rule that nobody really even cares about. The fact that he's poking at the lawyer that can't even defend himself is in and of itself should be enough to remove Judge DeThomasis from the case. Simple. And yet he refuses. So here we are. On a final note here, excuse me, Judge DeThomasis' order of February 28th also states, Florida Rules of General Practice and Judicial Administration 2.330H sets forth the requirement in reviewing a motion to disqualify as follows. If any motion is legally insufficient, an order denying the motion shall be immediately entered. Subsection C sets forth the requirements of a proper motion. Rule 2.330, again, from the book. This is the one that he continuously violates. If any motion is legally insufficient, an order denying the motion shall immediately be entered. No other reason for denial shall be stated. And he consistently just word vomit, word diarrhea in all of his orders. He doesn't have to do that. An order of denial shall not take issue with the motion, and he constantly takes issue with the motion. So recusal is merited, Court of Appeals. Please help. The judge's order doesn't quote the last two sentences of the rule, which ironically are the very sentences that prohibit Judge DeThomasis from writing these reductive multi-page single-space novella orders. Again, it's the I cherry pick. It's back to that whole I cherry pick. He's cherry picking which words help him and ignoring everything that hurts him. He's cherry picking even the rules. He's like, I like this part of the rule, so I'm going to write it and I'm going to use it. And I don't like this part of the rule, so I'm going to ignore it. And Jeremy's lawyers are pointing it out here in this motion. They're pointing it out. In Douglas, this court explained, this is, again, this court meaning the Court of Appeals that they're appealing to in the first district. In Douglas, you judges, explained the difference between considering a motion to disqualify under Section 3802, consanguinity, financial interest, etc., and a motion to disqualify under 3810, which is bias or prejudice. Under 02, a judge is allowed to pass on the truth of those allegations, which makes sense because the facts for disqualification under Section 02 are purely subjective, readily verifiable, and have nothing to do with people's sensibilities. However, when you talk about 38.10, on the other hand, means the litigant is claiming that her presiding judge is biased or prejudiced against her. That scenario necessarily brings in feelings and one's state of mind. The litigant's state of mind in this context, the fear of being tried by a tribunal that is not impartial must necessarily be paramount in order to protect the fundamental due process, Fifth Amendment right here, the fundamental due process rights of those who come before the court. By the way, those of you just joining us, don't forget to like the video, comment below, subscribe to the channel. I hope you're enjoying the show. I hope you're learning something, and I hope I'm making things as clear as I possibly can. Yes, I like to be theatrical from time to time. I hope that people like that. I don't know if you are or not, but that's just, you get to see the real me, that you get to see this is who I am. When I see an opportunity, I grab the bull by the horns. So let's keep going. It is irrelevant whether the judge agrees with the facts on which the fear is based. The fear that they're not going to have a judge who's biased, not biased and not prejudiced. It is the reasonableness of the party's belief, not the court's perception. We don't care. The rule doesn't care about what the court sees. It's only about the reasonable fear of the person. If I believe it's a subjective, not an objective, the judge keeps trying to make it an objective standard. He keeps trying to flip it and reverse it and basically put the burden on Jeremy to say why the judge should step down. And that's not the law. He is literally litigating from the bench. He's creating law that doesn't exist because he cherry picks what he likes, and what he doesn't like, he just puts to the side and ignores. And that's another reason for him to be removed from this case and in the future from the bench. It is the reasonableness of the party's belief, not the court's perception of its ability to act fairly, that matters. See, for example, Super Kids Bargain Store, Coucher, and maybe some other cases. The proper consideration is not whether a lawyer would question a judge's impartiality, but whether an ordinary litigant would reasonably question the judge's impartiality. There it is in a nutshell. Not whether a lawyer would question impartiality, but an ordinary person, ordinary litigant. Now, Hales' second disqualification motion, which was filed on February 11th, 2024, was based on Judge DeThomasis' conduct and comments at a non-evidentiary live hearing on January 23rd, 2024. And essentially, for 90 minutes, the judge barraged and or cross-examined attorney Shochet, the only attorney present on Hales' behalf that day, with hostile, accusatory, and degrading remarks that were actually directed to all three of Hales' attorneys for various perceived transgressions, past and present, discussed below. Infra is Latin for below. The judge's numerous disapproving comments about the Hales' earning income from his YouTube channel also exacerbated his fear of not getting a fair trial before Judge DeThomasis. And by the way, if you all remember, those of you just joining us, we kind of figured out why Judge DeThomasis is taking such umbrage. Why is he taking such painstaking? He's going so far out of his way to attack Jeremy. The judge has his own YouTube channel. He's got like somewhere around the vicinity of 2 digits. His subscribers are in the 2 digits. He's got a failed YouTube channel. I don't know, 43 subscribers, I think it was. Don't quote me on that. Don't even check it. There's no point. Like, why would you subscribe? There's nothing on there. There's like 3 testimonials from people we don't know if they're even real or not, his campaign video, and that I think there's like 1 more video. And the problem is he tried to make a successful YouTube channel at some point, clearly, because the page was made at least 5 years ago when he was running for judge back in 2019. I didn't actually check that, so don't quote me on this. But I know it's been made at least 5 years ago because the oldest video was 5 years old. And the problem is he failed. He failed at making a successful YouTube channel. Nobody really cared. Nobody was interested. And now he, in part, I'm starting to sense a little bit of jealousy on Judge DeThomasis as to the fact that look at the Haleses. Look at Jeremy and George. They're very successful with their YouTube channel. They're so successful that they have beggars and pleaders like Michelle Preston, who is coming after them to try and get money from them. Only he doesn't focus on that issue. He's just focused on the fact that apparently they're being stalkers. Which, why would someone with nearly 750,000, approaching 1 million subscribers on the YouTubes, care about someone who can barely feed her tortoises? Why would you stalk that doesn't make any sense. It doesn't even pass the basic precept of morality, of human decency. That just doesn't make any sense. And the fact that the judge is so focused on the rules and attacking the rules that he made up, by the way, the rules that he made up in his courtroom, and attacking the lawyers and the defendant, the respondent in this case, is just staggering. Is just absolutely staggering that he's unable to focus on the main event and actually, because this is a stalk. This all started from a stalking case. All he had to do was rule on it, and we wouldn't be here. The only reason we're here is because this judge went complete and utter rogue, and he just keeps stripping people away of rights, and that's not okay, and he needs to be removed. So the judge's numerous disapproving comments about the Hales earning income from his YouTube channel by themselves exacerbated the fear of Jeremy not being able to get a fair shake, a fair trial before Judge DeThomasis. Because remember, this is family court. You don't get a jury in family court. I'm like 99% sure this is all 50 states. I know you don't get one in Kentucky. The judge will literally listen to the evidence and issue a ruling. And they don't want to wait for him to issue some sort of injunction or grant something, because they know it's going to be adversarial. We know it's going to be adversarial. He's so biased against the Hales at this point. He needs to step down. He needs to step down because we can't get a fair shake in this courtroom. Okay. Now, from the audio-video recording, we can hear and see the judge's tone and demeanor. There is a discernible difference between the calm, attentive way in which the judge treated Preston's new attorney, his buddy, Josh Silverman, and didn't interrupt him when he spoke, versus the condescending, fault-finding, aggressive manner, replete with interruptions by the judge when dealing with the Hales' counsel. When it comes to a party's fear of not receiving an impartial hearing, there is no appreciable difference between statements directed towards a party or his counsel. That comes from Lohman, again, in the 1st District of Florida. Judge DeThomas's orders are not in conformity with Rule 2.330H. Now, another part of it. Hales has timely filed his second motion to disqualify the judge for bias on February 11th, 2024. And 3 days later, on Valentine's Day, Judge DeThomasis denied the motion in a 5-page, single-spaced, 2,549-word order. Why is this important? Why is this in bold? Because remember, Rule 2.330 that we already talked about right here. In any motion, if any motion is legally insufficient, an order denying the motion shall immediately be entered, and no other reason for the denial shall be stated. No other reason for the denial shall be stated. And here we go. He goes on for 2,549 words of no reason for denial shall be stated. And he states reasons for denial for almost 2,600 words in a 5-page single-spaced order that took issue with the allegations in the second disqualification motion and denigrated Hale's attorneys even further, including veiled threats. You remember we read this. Veiled threats that he's going to report all 3 to the Florida bar. I mean, talk about an egregious conduct, egregious threat, egregious behavior by a judge. I've never seen anything like it. I've never seen anything like it rising to this level of disgusting behavior from the bench. It's disgusting. The embellished order of Valentine's Day became an independent basis by itself. The order speaks for itself, Your Honor. The order speaks for itself. For Hales' third disqualification motion, which was filed and served 1 week after entry of the Valentine's Day order, see Manuel. Again, when a judge has looked, this is Manuel case, when a judge has looked beyond the mere legal sufficiency of a suggestion of prejudice and attempted to refute the charges of partiality, he has then exceeded the proper scope of his inquiry, and on that basis alone, we don't need anything else. We don't need anything else. On that basis alone, establish grounds for his disqualification. That's Charlotte, another 1st District case. Now, the Valentine's Day and the 228 orders impermissibly refute allegations in the disqualification motions. Despite the judge's bare contentions in both orders that he was not, quote-unquote, passing judgment on the truth of the facts alleged, he did so. In fact, it is rather troubling that Judge DeThomasis confidently states that neither his 5-page single-spaced order of Valentine's Day nor his 3-page single-spaced order of 228 passed on or took issue with any facts. The record already reflects these orders passed on at least some of the facts directly. For example, in the Valentine's Day order, on paragraph 9, Judge DeThomasis wrote, quote, any objective review of the proceedings held on January 23rd would not cause a reasonably prudent person to fear not receiving a fair trial. If you've been following my review of these, you know that this is exactly what he said, and they're quoting it here. First, this comment is in direct rebuttal to Hales' statements in his motions regarding his fear of not receiving a fair trial. And thus, it's improper commentary by the trial court. He has no right to speak this way to us, judges. Judges of the Court of Appeals of the First Circuit of Florida, please help us. It is improper commentary for DeThomasis to talk to us this way. He doesn't have a right to do this. The judge's declaration, moreover, is not reality-based. He's out of touch with reality. Certainly not after one views the video recording of the proceedings. As the defendant in this case, Hales had a very different perspective than that of the judge. Hales had a front row seat at counsel table on January 23rd, 2024, and experienced personally, firsthand, the intolerable adversarial atmosphere between his side of the case and Judge DeThomasis. The remainder of paragraph 9 then attempts to justify the court's hostile conduct towards Hales' attorney with vague accusations of their unacceptable behavior contrary to law. Another obvious example of the judges impermissibly taking issue with allegations in the disqualification motion is in paragraph 9A of that order. There, the judge directly addresses and refutes paragraphs 11 and 12 of Hales' second disqualification motion, stating that his averments are, quote-unquote, illogical, irrelevant, and inconsequential. Now, although it appears the judge misunderstood the nature of an argument advanced in the alternative as being the same as two arguments involving competing hypotheses, quote unquote, he nonetheless should have refrained from offering any comment at all, considering he was drafting an order denying a motion to disqualify. Judge DeThomas's impermissible rebuttal of factual allegations contained in Hales' motions was not cured by a threadbare qualifier that, as Judge said, and you all judges have said previously, because they're citing the case again, that he was not passing judgment on the truth of the facts alleged contained in the motion. And the lawyers disagree. And I think we all disagree at this point as well, because look how far we've come. Look, we're already, that's it. We're in the Court of Appeals now. The proceedings in the circuit court are frozen. Judge DeThomasis, as the thumbnail suggests, is frozen in ice. Unfortunately, the temporary protective order is still in place against Jeremy, and as long as it takes for the judges to rule, and this is the most disgusting part, we don't know how long it's going to take them to read all of this and rule on it. Hopefully they'll do it quickly, because time is of the essence. Jeremy is literally in purgatory, literally in purgatory. He's sitting in purgatory. He's waiting for a ruling just so that he can move forward and continue on with his life from this horrific stalker named Lynette Preston that won't leave him alone, begging for money and all that. That's where it all started. It's hard to believe that that's where it all started. And look where we are. We're trying to remove a judge from the bench. And you know what? To be completely honest, for that, I'm thankful. This is what I'm thankful for. I am thankful for the fact that we actually have a judge who, well, this is not what I'm thankful for. I'm thankful for the fact that this case, Jeremy Hales' case, has brought to light from the shadows a very corrupt figure that has been messing with people, taking away their rights, and messing with people's lives. Clearly, a judge who acts like this on the bench, on the record, there's no way that this is their first rodeo. They've done this before. They've done similar things before, and they're going to continue to do these things. And I thought he was up for re-election in April, but my sources tell me that he's not up for re-election until 2026. Unfortunately, it's a 6-year term, not a 4-year term, which is very unfortunate. But I'm very happy and I'm very glad that Jeremy Hale, unfortunately, Jeremy Hale is the martyr here. He's the one suffering throughout all this. I am happy that Judge DeThomasis has now been brought to light. His conduct has been brought to light, and now he's being dealt with. The merits of Jeremy's case and Lynette's petition have not yet been examined, JW. That is established. That is already established. Great question. The order, with its repeated accusations of ethical misconduct on the part of the Hales' attorney, exacerbates the intolerable adversary atmosphere between the trial judge and the litigant that the disqualification rule was designed to prevent. That's Department of Revenue versus Golder. In conformity with the legal authority already cited herein, the 5-page single-spaced order denying Hales' second disqualification motion by itself is an independent basis to disqualify Judge DeThomasis. The actual content, the language, the tone of the order further provide additional bases to disqualify this judge as set forth below, and further establish that Hales' fear of not receiving a fair trial before this judge is indeed well-founded. So that was argument number 1 of Jeremy and his lawyers. Now let's go to argument number 2. Judge DeThomasis. Judge DeThomas's running polemic on counsel's unacceptable behaviors and actions contrary to law, plus the veiled threats to report counsel to the Florida bar, are objectively reasonable bases for Hales to fear he will not receive a fair trial with this judge. Okay. Polemic, by the way, for those of you who don't know, let me pull up the definition. A speech or piece of writing expressing strongly critical attack or controversial opinion about someone or something. So being strongly critical or controversial, criticizing very aggressively. To be sure, a judge who questions the veracity or ethics of a party or counsel may be subject to disqualification depending on the unique facts of the case. That comes from Klein, a case we've seen before. In his Valentine's Day order, Judge DeThomasis stated 4 different times that he admonished counsel, meaning he told them no, 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 at the hearing on January 23rd for certain perceived transgressions going back to November 29th, 2023, before Shochet was even involved in the case. That's when Mark Feather was there. Mark Feather. Shochet was the only attorney who appeared with Hales in court on January 23rd, 2024, and not responsible for the court's consternation last November. And yet, nonetheless, Judge DeThomasis punished Shochet for Feather's purported offenses, as well as those that the judge believed belonged exclusively to Shochet. If you watch the video recording of January 23rd, it reveals that what those admonishments really look like. Portions of paragraph 8 and 9 of Judge DeThomas's Valentine's Day order read as follows. It is the court's responsibility to assure counsel's adherence to regulations of the bar, as well as a code of professional conduct in their dealings with the court, court personnel, and opposing counsel. It is necessarily an obligation of the court to question counsel regarding behaviors affecting the administration of justice, and to place on the record the specific critical concerns of the court, as was done in each of the prior hearings, and to allow response of counsel, if any, concerning any and all transgressions and or violations of the law and or standards of conduct that directly affect the legal process of the case to be adjudicated by the court. As we can see, Judge DeThomasis indicates above that after his criticisms are placed on the record, as done at each prior hearing, the court's responsibility is to allow response of counsel, if any. Although there is quite a bit of evidence in the record of the court questioning counsel, including excerpted in the following section, there does not seem to be much record, if any, of counsel responding to the court and even being allowed to do so. So the judge is basically attacking us, your honors. Please help remove him, because even when he's accusing us of stuff, he doesn't give us a chance to respond. He's literally attacking us without giving us a chance to respond. How horrific is that? He's attacking us, and then when asking, respond to it, and we begin to answer, he moves on to the next thing. He's even depriving counsel of their right to confront their accuser, and their accuser in this case is Judge DeThomasis. By the way, don't forget to like this video, comment below, subscribe to the channel if you haven't already. My goodness, we have over 8,000 of you in here. We're approaching 9,000 people. That's crazy, but I'm not surprised. I mean, this needs national attention. I'm still trying to get on Megyn Kelly, by the way. I know some of you have been helping, and God bless you, honestly. Thank you so much. I don't know if we're going to be able to get to her by the end of the day, but we keep on churning. We keep on churning, and we have everybody working on this. The whole world is watching. The whole world is working on this. The whole world wants this to come to light. The whole world wants Judge DeThomasis removed from this case. And I think most of the world at this point, correct me if I'm wrong, wants Judge DeThomasis removed from the bench, period. You can go back to practicing law. He may be a great lawyer. I don't know anything about him. But actually, I did learn one new piece of information. I did want to share this with you all. This is news, okay, at least to me. So it may not be news to you, but it is news to me. So in 1999, Judge DeThomasis was a lawyer. In 1999, he represented a woman who was a stripper, who was invited to a party, a frat party. It was her and her friend, okay? Then the stripper ended up leaving. Her and her friend left the fraternity party, and then one of them came back to the party and was allegedly AR'd. She was allegedly SA'd by the fraternity. There was a movie made about it with actual video footage because the bastards recorded the whole thing on camera. And the reviews are kind of split, okay? The reviews are kind of split. Did she do it? Was she complicit? Because allegedly there were some moments in there where she kind of goes, does this make you feel like a man? Does this make you feel like a strong man by doing this to me? Like, she's egging him on in the video. She's egging him on because he is starting to take advantage of her in the video. I have not seen it. I've not seen the movie, but I know it's out there. It's a 2001 basically documentary. And it's about Judge DeThomasis, his client. How does she become his client? You know, I asked around, and I finally got this piece of information. I found out that Judge DeThomasis, at the time he was a lawyer, she came to his office asking him to represent her, but not in like a civil case trying to get money from these assholes who allegedly SA'd her, which is what I thought, because it doesn't go into detail and I didn't watch the movie yet. I mean, never. I mean, it sounds so graphic and horrific. Excuse me. Anyway, the point is, Judge DeThomasis, at the time lawyer, attorney DeThomasis, Craig DeThomasis, the one we're talking about in this video, represented her. But he didn't represent her in the civil case. She was criminally prosecuted for perjury. Here's what happened. After she comes out and says, these frat boys SA'd me, please help me, the police investigated and they said, we don't see nothing wrong here, so we're not going to be pressing any charges. But at some point, they said, you know what, lady? I think the fact that you came out and accused them at some point because of maybe in the complaint, maybe in the whatever, you perjured yourself. And they charged her with perjury. And they began to criminally prosecute this stripper, or at the time, ex-stripper, I don't know anymore at this point, for perjury. They began prosecuting her for perjury. And Judge DeThomasis, at the time, lawyer DeThomasis, attorney DeThomasis, was one of the lawyers who represented her in the criminal case. He was a criminal defense attorney who represented her in the perjury charges. Now, for better or for worse, I don't know. You be the judge here, because I don't know the full facts. Like I said, I've not seen the documentary. I cannot give you a cogent, logical, reasoned argument as to why or why not. But Judge DeThomasis, at the time, attorney DeThomasis, lost the case, and she ended up getting convicted. I don't know if she served any jail time, but she was convicted of the perjury charge, and it went on her record sometime in the early 2000s. So that she went to jail. People are saying she went to jail. So maybe you guys know. Maybe you guys know. Dorothy says, true, the good old boys club of Levy County are trying to deplete. Oh, sorry. I thought you were talking about this. And the history that just repeats itself. Exactly. So she was convicted of perjury. And again, look, I'm a criminal defense attorney. Do I win every single case that comes across my desk? If I did, I would probably be representing, presidents at this point. But the reality is, it's difficult sometimes to win a criminal defense case. But the fact that she ended up going to jail on a perjury charge, I mean, that is low. You have to be so bad as a lawyer. I mean, again, no offense, but maybe she deserved it. It's hard to say because, again, SA is involved. And anytime there's R and SA in the title, it's like, literally, we saw it with the Johnny Depp Amber Heard situation, right? I mean, we all want Amber Heard to serve jail time because she falsely accused him. Look at this case. It's this stripper allegedly, falsely accused these frat boys. But based on the comments I read, it's not so cut and dry. It was not a very easy decision, an easy case. And like I said, if I knew more facts, I'd be able to tell you. but I don't. But I do know that she ended up getting convicted, and now you all know she ended up going to jail. Jen is saying she got a raw deal. So she ended up probably pleading guilty and going to jail over it. And Dorothy is saying there is more to that story. And I'm sure there is. I just wanted to give you a preview of something that we may do in the future. But let's get back to the motion. But essentially, just so you understand, attorney DeThomasis in the late 90s, early 2000s represented a stripper that accused frat boys of essaying her. She later, she never recanted. She held to the bitter end. They ended up not charging the frat boys and actually charging the stripper for lying, perjury, and thanks to the quality representation of Craig Constantine DeThomasis, she ended up getting convicted and going to jail. Those are the facts. The rest will come later. And no, I'm not of the believe all women mindset. I'm of believe the truth. Do not believe all women. Oh my God, no. We learned that with the Amber Heard case. Oh my God, no. Dear God, no. I believe the facts. I believe the evidence. I believe some women who have facts and evidence. I do not believe all women. Fuck that shit. Judge DeThomasis, for example, accused Mark Feather of 3 transgressions. The misrepresentation on November 29th about Hales having to go to Ohio. Number 2, violations of administrative orders regarding unredacted versus redacted recordings obtained. And number 3, Feather stated that he would be done with the case 15 minutes at the end of the day on November 29th. Mark Feather, however, did not appear. He could not even defend himself in court after November 29th, 2023. And he formally withdrew from the case on or about February 23rd, 2024, just last week, a week ago. The only order to show cause Feather received came from Chief Judge Mosley, and Feather was called to answer to the Chief Judge, which he did, and the matter should be resolved. The point is, there does not seem to be any evidence in this record that Judge DeThomasis followed his own order and requested or sought a response directly from Feather before the judge metaphorically tarred and feathered him without giving him an opportunity to be heard, and then repeatedly condemned him feather in absentia at each and every subsequent hearing. Let me read this again, because this is the most beautifully written sentence. There's a lot of what is that word called? Epatomonimia. It's when you, oh my God, I can't think of the term. Onomatopoeia. No, I forget. I can't think of it. But listen to this language. The point is, there does not seem to be any evidence in the record that Judge DeThomasis followed his own order and requested or sought response directly from Feather before the judge metaphorically. And before the judge, Judge DeThomasis metaphorically tarred and feathered Mark Feather. Because you remember when they used to do, like, when you would be embarrassed publicly, they would throw tar on you and then just drop a bunch of feathers, because tar is very difficult to remove, and feathers would stick to the tar, and you'd basically have this on your body for like 3 days. I mean, it's just phenomenal ways of describing. What does scribs mean? Hatsune versus Miku. I'm not sure what that means. Scribs? Fill me in. I might be missing something. There might be an inside joke there. Without giving him an opportunity to be heard. He doesn't even give a chance to man to defend himself. And then repeatedly condemned him, feather in absentia. Again, it's just, look at those words. Look at the way Doreen and Randy are just, and this is mostly Doreen as I understand it. So props to you. We're going to have a movie's going to be made on this one day. And you know who's going to play, I think I know who's going to play Doreen. It's going to be, what's her name? From Leon the Professional. What's her name? Oh my God. Star Wars, V for Vendetta, Leon the Professional. What's that female actress? Help me out here. she's going to play Doreen because this is the only, I mean, look at that language, that colorful language, feather in absentia, tarred and feathered. Mr. Feather has gone through so much. It's a simile. Yeah, it is. Natalie Portman. Thank you. Natalie Portman. Due process requires that a judge possess neither actual nor perceived bias. That comes from JJN FLB LLC. A judge's fundamental responsibility is to protect the constitutional rights of others. A judge's callous disregard for the constitutional rights of the people who appear before him is the antithesis of his judicial obligation. It's the opposite of what should be. That's an inquiry concerning a Judge Sloop. That's a direct cite. Judge DeThomas's obtuse language and veiled threats suggestive of reports being made to the Florida bar for the attorneys to be called upon to account for their behaviors or to answer and explain their behaviors and to be admonished doesn't belong in his courtroom. Just doesn't belong there. At the other end of Judge DeThomas's due process spectrum is paragraph 9 of the Valentine's Day order. To grant disqualification on the basis of the matters averred in the motion under review, which consists of confronting counsel with their unacceptable behaviors and actions contrary to law, would be tantamount to allowing lawyers and litigants to violate rules and to the rules promulgated by the Florida Supreme Court. Orders issued by the Chief Justice of the Florida Supreme Court and orders issued by the Chief Judge of the 8th Judicial Circuit, and to surrender and abandon all precepts of the regulated practice of law. Like, we have to abandon everything for this guy in order for him to even begin to use his legal procedure properly. He's like, no, this is not how it works, Judge. And if they're then called upon to account for such behaviors and or to answer or explain such behaviors and or are admonished for doing so, they should be allowed a fresh start with a successor judge. That's it. The other end of the spectrum for Hales and for the attorneys, the judge's words in his own February 14th Valentine's Day order, who is now necessarily concerned that each foray into Judge DeThomas's courtroom will involve 15 minutes of preliminary attorney inquisition. Listen to that. Understand what he's saying here, what Doreen and Randy are saying here. They're worried that every time we step foot in the courtroom, we have to brace ourselves for 15 minutes of attack. Then we're going to have 30 minutes of figuring out scheduling and listening to the judge talk about previous court dates. And then we're going to have to reschedule for a new court date to hear it on the merits. And it's basically going to be an endless cycle, an endless loop of never-ending non-litigation litigation of just the judge bitching and moaning about the attorneys, bitching and moaning about Jeremy, bitching and moaning about what has been happening, bitching and moaning about court dates, meticulously going, at 3:17 p.m. on November 29th, I said the words, and going back in time. And by the time we get to like September, we're never going to hear of this year. We're never going to hear a chance to hear the case on the merits. That's what the lawyers are saying here. They're worried about this. They're very, very worried about this. Will involve 15 minutes of preliminary attorney inquisition on collateral matters. What does that mean? Collateral matters? Matters that are not related to the case at hand. Matters that are not related to the case at hand. And not to mention, at his own expense, Jeremy has to pay for all of this out of his own pocket before the merits of his case are even addressed. He's milking, basically, because Lynette can show up there without a lawyer. It's her petition. She's got no problems. Jeremy needs a lawyer there to be there at every step of the litigation. And secretly, I think we already went over this. We already covered this. I'm of the opinion that the judge secretly hopes that Jeremy will run out of money. His lawyers will not come to court. Jeremy will come in by himself, and the judge will just have a field day, grant Lynette's motion, and call it a day. That's what he's secretly hoping for. And he'll never admit to it because he's trying to be unbiased and unprejudicial and fair and just. Come on, man. We've seen it all. We've seen it all. You have outed yourself on video. You have outed yourself on camera. You have outed yourself in your orders. You have outed yourself in your orders denying motion to disqualify. There is no more hiding, Judge DeThomasis. The light has come and it wants a scalp. The light wants a scalp. And it will get one way or another. If you're not going to give it to us, we will take it. We will use the Court of Appeals to take it, to remove you. Indeed, the record already reflects his intention to indulge in this exercise regarding a sequestration issue, which the judge appears to be applying in an overly broad fashion to the Haleses and his witnesses who have not yet begun testifying nor were even sworn. Specifically, Judge DeThomasis stated that when parties return for trial on March 1st, which would have been today, the court will start with conducting an inquiry as to who spoke to who and is going to issue sanctions, including the exclusion of testimony. Are you fucking kidding me? The judge is in no position to determine who can speak to who and who can. No, you don't do that. That's not your job. You put the witnesses on the stand and you listen to them. You don't put them on the stand, listen to who they talk to, and then listen to them. Bring them to the stand, listen to who they talk to and what they're about to say, determine whether or not you're going to listen to their testimony, and then say, okay, you talk, you know, you talk, you know, and you know, and no, and maybe I'll decide later and no. That's not how it works. Jeremy brings in his witnesses and he puts them on the stand. As the respondent, he has a right to do so. He has a right to confront his accuser, Lynette. And now he has a right to confront his accusers, Lynette and Judge DeThomasis. They're both in the same team now, both attacking one man who is now appealing to the Court of Appeals. It's all full circle, folks. It is all connected. All the dots lead to Judge DeThomasis. All roads lead to Rome. In light of the demonstrable history of this judge's disparate treatment of the parties, including selective interpretation and application of administrative cherry picking, including selective interpretation and application of administrative and procedural rules as between the parties in this case, and his hostility and express condemnation of Hales' counsel, Hales' fear of not receiving a fair trial is both well-founded and reasonable. The doctrine of judicial independence does not afford judges the power to do as they please. They can't just do whatever they want. For instance, inquiry concerning a Judge Erickson, that's where it comes from, that rule. It's obvious, but we're citing law here again. Judge DeThomas's professed justification in his order that it is the court's responsibility to assure the orderly administration of justice does not justify retaliatory conduct against the attorneys or the parties, nor does alleged misconduct or the good motives of a judge excuse departure from the guidelines established in the Code of Judicial Conduct. For example, see also In Re Inquiry of Judge Shochet. As the Florida Supreme Court stated in Erickson above, this is what they said before on another judge who was acting unruly. Judge Erickson, this is the Florida Supreme Court, okay? Florida Supreme Court. This is the one that sits above the Court of Appeals. So the Court of Appeals is bound by this language. Judge Erickson essentially believes that if a judge believes a defendant who exercises a legal right in an attempt to interfere with the orderly administration of justice, the judge has the right to react to the defendant by inflicting punishment upon him or her. Sound familiar? However, if a defendant knows that the exercise of a legal right may interfere with the orderly administration of justice, the judge cannot punish the defendant just because they're exercising that legal right. To approve that approach would have a chilling effect, certainly, on defendants who legitimately seek to exercise their legal rights and is contrary to the fundamental principles of due process. That's exactly what's happening here. Now, argument number 3 as to why you Court of Appeals judges should remove Judge DeThomasis from the case. Judge DeThomas's hostility and animosity towards Hales' counsel is also a basis for his disqualification. References to the record are taken from the official redacted video recording of the January 23rd, 2024 hearing. And we have a footnote: the transcript of the January 23rd proceeding is not yet ready, and supplementation of the record to include it will be requested. Again, because he rushed the process, Judge DeThomasis did so much, they didn't get a chance to get everything prepared. If he gave them a week like they requested, it would have been ready. But you can't get everything done in 24 hours. That's not possible. Courts are very slow to move. Courts are very slow to act. And Judge DeThomasis knows it, and he intentionally basically bound and gagged not just Jeremy, but he also tried to gag his lawyers. Like, if you don't file this in the next 24 hours, I'm not going to give you an opportunity, and we're going to trial on Friday. It's ridiculous. It is absolutely insanity. The bracketed timestamps next to quoted excerpts of the proceeding are as close as possible to the time increment on the recording. The judge's bias against Feather. Paragraph 7A through C, which we've gone over previously in our animated section earlier of the order. By the way, shout out in the chat if you liked it or you hated it or you don't care or you want more. I'm curious. Paragraph 7A through C of the order addresses court hearings that occurred early on in the case on November 29th, 2023 and December 6th, 2023. Attorney Feather, Mark Feather, represented Hales at the November 29th proceeding. Attorney Shochet Law Group, entered an appearance shortly before the December 6th hearing. Okay, people, I think people are universally saying we want more. I will remember that. You guys asked for it. You guys asked for it. Now you can't take it back. Thank you, guys. Honestly, thank you. What Judge DeThomasis apparently perceived as egregious misconduct during and surrounding these early hearings quickly became a running polemic, there's that word again, adversarial, confrontational, that continues to this day, and it is being used to justify denial of due process to the Hales. Paragraph 7A references a statement made by Attorney Feather to the court at the end of the day on November 29th, 2023, regarding the possibility of concluding the hearing that had not finished the next morning at 9 a.m. And Mr. Feather's words were, "No, Your Honor, Mr. Hales is having to address a matter in Ohio court related to this situation. He has to be there tomorrow morning." The court thus scheduled conclusion of the hearing for December 6, 2023. From Feather's statement, the judge assumed that Hales had to be present at a court proceeding the next morning in Ohio court, rather than consider the possibility that Feather simply misspoke or failed to phrase his response more articulately. The judge immediately reached the adverse conclusion that Feather intentionally displayed a lack of candor with this tribunal. In simple terms, you lied to me. Lack of candor with this tribunal means lied to me. Candor is truthfulness. Tribunal is the judge, the court, me, DeThomasis. So you lied to me, Mr. Feather, Mark Feather, and obtained a longer continuance for his client based on a misrepresentation, another fancy word for lie, which was not what happened. Ironically, on the electronic recording of the January 23rd hearing, the court, speaking rapidly, stated that anyone, quote, anyone after this judge has spent 40 years almost on a daily basis in a courtroom. That's a very fascinating statement, by the way, in and of itself, because we know that Judge DeThomasis has been practicing law for a few decades now. That's no secret. That's no surprise. We're aware. We know. But the way he phrased it, because, you know, he's only been on the bench for like 4 years. And 2.5, 3 of those years were COVID years. So he never really got a chance to be a judge. He only now is finally getting cases before him on a regular basis and in person. Now that we're back in person over the last, just year and a half. It's hard to believe that it's only been like a year and a half since we're all been, for the most part, in person in court. But there was a time when everything was done by a Zoom. And courts have been, court cases have been pushed out and further and further and further out. Excuse me. Although that statement, Jeremy's lawyers go on, although that statement gives the impression that Judge DeThomasis has been serving as a judge on the bench for 40 years, we know that not to be the case. Immediately assuming that the judge lied in making that statement when he merely did not articulate his words carefully would be absurd. Of course, they're just making a hyperbole. They're showing that, look, Mark Feather misspoke just like you misspoke, Judge. We're all human. Things happen. You can't be so nitty-gritty and nitty-picky about every tiny little thing, about the way he talks. I mean, Megan pointed this out. Megan Fox, by the way, shout out to you. Thanks again for the raid earlier. But think about it. Megan has brought this out. Look at how meticulous he is. On November 29th at 7:37 p.m., you filed a motion, and it was 5 minutes late because the deadline for that was 7:32, and you filed it at 7:37. Normal humans don't talk like that. Even judges. I practice in front of judges all the time. Dates are very important to us. When did things happen? What time did things happen? Sometimes matter. But Judge DeThomasis makes such a big deal out of it, such a huge deal out of it, that it makes absolutely no sense. Why is he so focused He's so hyper-focused, laser-focused on the things that do not matter, that have nothing to do with the merits of this case. Nobody cares, man. Nobody cares. That's the doobie, bro. Ain't nobody cares at this point. You know what I mean, dude? Nobody cares. Can we just like talk about the merits for a second, bro? Can we like talk about the case for a minute? Because like this woman has filed a petition against me, man. And excuse me. I want to defend myself in court, man. Can I have my guns back? Can I have my guns back? I wanna like actually like have my day in court. You're not giving me my day in court, bruh. Here you guys go. Oh, it's absurd. Nonetheless, in his order, Judge DeThomasis continues to impugn Feather with his statement months later after having reached a negative conclusion without ever affording Feather an opportunity to be heard. Again, attacking a man that's not even in the room. Such conduct is the antithesis of impartiality. He's clearly partial. He needs to be removed. It is apparent that the court's bias against Feather manifested itself at that point early on when the judge assumed without anything more that Feather lied to the court. That's all it took. It quickly intensified when the court also learned soon thereafter that Feather requested and obtained the unredacted versions of video recordings of the November 29th and December 6th hearings, which he provided to the Hales. To Hales, Jeremy, because again, remember, it's Jeremy is even though it's Jeremy and George, it's their channel. Jeremy is the only one who Lynette has the petition against. So every time the Judge DeThomasis attacks Hales, he's attacking Jeremy because Jeremy is the one in court. There is no petition against George in Florida that I know of, and I don't think one exists, who broadcast them in conjunction with his YouTube program, What the Hales, right? And that's where Judge takes umbrage. Judge DeThomasis, as we know, takes umbrage with this. He says, Jeremy is What the Hales channel on YouTube. What the Hales channel on YouTube is Jeremy. There's no differentiation between the two, and that is false. That is a lie. That is not how it works, Judge. Once bias became manifest, confirmation bias followed. This is a basic precept of human psychology, but it is also documented within the laws of the United States and, of course, the Florida district courts. What is confirmation bias? Confirmation bias is the well-documented tendency, once one has made up one's mind, to search harder for evidence that confirms rather than contradicts one's initial judgment. See Yerkes, a 4th District Florida case. And Florida Supreme Court Administrative Order 1122, which was designed to further standardize court operations and to minimize unnecessary workload for the trial courts while continuing to protect from inappropriate release any confidential information. Remember, we talked about this. The purpose of the order was to make sure that like social security numbers, dates of birth, children's names, things that don't belong in the public eye be redacted. Those things can be redacted by the court, no problem, easy. There's none of that here. There's none of that here in this case. That was the purpose of the rule, that any confidential information that may be captured on electronic recordings in Local Administrative Order 1.14 version 2 of the 8th Judicial Circuit contain procedures for obtaining copies of electronically recorded court proceedings. Section 5 of the Local Administrative Order, entitled Safeguarding Confidential Communications when Electronic Recording Equipment is Used in the Courtroom, states, pursuant to Florida Supreme Court Administrative Order AOC 0621, as amended, before any CD is released to a non-party, in a case, it shall be redacted of any confidential material found therein. And for those of you paying attention, for those of you who have been following for a while, you know that the redacted version and the unredacted version, if you put them on top of each other, they're exactly the same length. Not a second different, which means nothing has been redacted, because as soon as you redact something, what's going to happen? The redacted version is going to be just slightly shorter, even by 1 second, 2 seconds, 5 seconds, 12 seconds, however long it takes in order to get the redaction. The redacted copy, that means the clerk sat there, watched the tape and said, there's nothing to redact here. I spent my time. Thank you for the extra fee. Here is the redacted version, and it is exactly the same as the unredacted version. That's the case in this case. So any confidential material found therein, which there was none, and the judge still took umbrage with that. AOSC 1122 provides that copies of audio-video recordings may be made available to attorneys of record, parties to a case, and self-represented litigants upon request, so long as they acknowledge, and the acknowledgement is provided with the copy that states that confidential information may be contained on those recordings, and further dissemination of confidential information contained on the recording is prohibited. That's not allowed, which did not happen. Jeremy never disseminated confidential information. And violation of the prohibition against dissemination may subject the requester to an action for contempt of court. Now, as Attorney Feather signed the required acknowledgement when he requested the two unredacted recordings and unwittingly furnished them to the Hales, they published them on his YouTube program, and Feather received an order to show cause issued by Chief Justice Mosley on January 17th, requiring him to appear before the Chief Judge and to show cause why he should not be held in contempt for purportedly, allegedly, violating the Supreme Court and local administrative rules as to the unredacted recordings. Feather appeared with counsel before the Chief Judge on February 7th, 2024, so just less than a month ago, 3 weeks ago, 3.5 weeks ago, and received a sanction commensurate with the offense, the monetary portion of which was vacated sua sponte, meaning vacated by the court without any motion. This administrative matter involved Feather was collateral to the instant court proceeding, basically had nothing to do with it. However, Judge DeThomasis made it the centerpiece. Now that the Chief Judge of the 8th Judicial Circuit took charge of Feather's matter, not Judge DeThomasis, indicates that keeping the matter separate was intentional. He did not want Chief Judge Mosley did not want to give Judge DeThomasis the job. He took care of it. That indicates that keeping the matter separate was intentional and important so as to avoid even the appearance of prejudice to Hales arising from his own attorney being sanctioned by the judge deciding the merits of the Hales' case. That's how careful Mosley was to show that I am unbiased. I'm trying to make this as clean and easy for the Hales because I don't want him to feel that he's being affected by this. That's very important. That's a very, very important point. That objective was not and could not be accomplished because, as we all have seen, and if you haven't, go check it out. It's on What the Hales' channel, as shown by Judge DeThomas's comments and demeanor in the video recording of the January 23rd proceedings. We also did this on Megan's channel. It is on Megan Fox Writer's channel. Shout out again to you, Megan. Thank you for the raid earlier. January 23rd proceeding, he could not keep his antipathy toward Feather from impacting his judgment on substantive issues in the Hales' case. And confirmation bias also extends to attorney Shochet at the January 23rd hearing. By the way, don't forget to like this video, comment below, subscribe to the channel if you haven't already, and don't forget to also hit that notification bell, join on as a member. If you have questions, which I know you do, there's like 83 of you waiting, which I'll go over at the end of this video. If you have questions, if you want to subscribe to the channel, if you want to support us, now is the time. Go and ask your questions and I will address them in due course. In paragraph 7C of the Valentine's Day order denying Hales' second disqualification motion, Judge DeThomasis makes it appear that he was the trier of fact over Mark Feather's administrative contempt matter, which he was not. Again, placing himself in the shoes of another, just trying to feel that, get a feeling for that power, that ego boost, that, I can't. Made adverse findings against Feather and admonished Feather accordingly. He admonished Feather, who wasn't in the room, based on an admonishment not made by him but by another judge. There was undisputed evidence that confirmed attorney for the respondent, which is Jeremy Hales, Mark Feather, Mark Feather, despite having previously signed an attestation that he was aware of the admonition regarding the prohibition against dissemination of unredacted copies of court proceedings, did in fact disseminate, and there's a footnote, bolding here done by Judge DeThomasis. This is not us. Unless indicated that emphasis was added by the judge, all emphases added with bold, underlined, or italicized font were done by this writer. Did in fact disseminate an unredacted copy of the 11/29/23 court proceeding, as he was the only person to have requested. So he checked who requested this copy. He checked who requested this copy. He was the only person who have requested an unredacted copy, and his client, the respondent, Jeremy Hales, did then broadcast the unredacted copy on his social media platform. Brrr, the YouTubes. It is true, as alleged in the motion under review, that counsel was admonished on January 23rd, 24, for such behavior as it was contrary to the dictates of the Florida Supreme Court and the Chief Judge of the 8th Judicial Circuit. In paragraph 7D, the judge continues, it is true that on January 23rd, 2024, the court did express dissatisfaction and admonished counsel, who wasn't even there to defend himself, and the respondent, Jeremy, for broadcasting unredacted audio-video recordings of court proceedings, despite it goes on. Paragraph 7B about Feather's perceived misrepresentation to the court. The judge continues. During the proceedings held on December 6, 2023, this court learned from co-counsel Randy Shochet and the respondent Jeremy Hales himself on the record that the respondent did not actually need to appear in Ohio court on 11/30/23 and that he only needed to sign some documents. He needed a pen and paper. Why was he not coming to court 2 days later with his Ohio attorney? Now, as a direct result, it is true, as alleged in the motion under review, that the court did admonish counsel for the lack of candor towards this tribunal, and such behavior was again addressed on January 23rd, 2024, as the court considered the totality of the circumstances in the case when deliberating on additional motions being adjudicated. Mark Feather, however, did not appear at the January 23rd hearing, nor any hearings after November 29th, 2023. That was the last time he came to court. Only attorney Shochet appeared in court from December 6th forward, and the judge continuously takes umbrage with the fact that Feather did this, Feather did that, Feather did this, Feather did that, because it's easy to attack a straw man, a man that's not even there, a person that's not even there, the straw man argument. It's an ad hominem. It's both an ad hominem and a straw man fallacy. Ad hominem is when you say, well, Your Honor, you deprived me of my First Amendment right. And the judge says, well, your face is ugly, so I rule against you. And you're like, wait a minute, you didn't address the fact that you took away my First Amendment right. Yeah, but you have an ugly face, so you lose. That's an ad hominem attack. That's attacking the person. It's called a logical fallacy. You address nothing the person said, and you're attacking them just because of the way that they look, right? It's a fallacy in logic. There's another fallacy. It's called the straw man argument. It's a redirection, and this is also being used here. It's a redirection attacking against the person. A straw man argument would work like this, and I can use this case as an example. Your Honor, Mr. Hales is being deprived of his First Amendment right. We're going to use the same example. Well, because Mark Feather did not have candor towards the tribunal, I am going to issue a new continuance. Like, wait, hold on, Your Honor, we're not talking about this. Well, Mark Feather, straw man. He's pointing towards something else that you're not talking about that is bothering him. That is a straw man ad hominem attack. He's creating this tar and feather figure sitting like a cloak and dagger shadow sitting next to Jeremy that's not there, that can't defend himself, doesn't exist in the flesh, especially now that he withdrew. He's not even on the case anymore. And he's attacking him personally. So he created a straw man, tarred and feathered him, pun intended, and he's continuously doing this ad hominem personal attack. Well, I didn't like what he did. I don't approve of what he did. And now the lawyer, Jeremy's lawyer, is standing there going, can we talk about the case? And the judge is like, I'm not finished yet. You see the problem? Although Shochet was not even involved in the case at that time of the 11/29/23 hearing, and although he was merely the messenger at the December 6th hearing, the face of the order shows that Judge DeThomasis' bias became directed at Shochet, whom the judge undeservedly yet repeatedly admonished at the January 23rd hearing for the alleged offenses Shochet didn't commit, nor could have committed. Moreover, as to Mark Feather's administrative matter involving the in-court video recordings, not only did Judge DeThomasis admonish Shochet on January 23rd without any cause, because Shochet was not responsible, but he did so without proper authority because the chief judge has already done that. He has already assumed responsibility over that collateral matter. Drunk on power is another phrase I could say. Cherry picking and drunk on power is Judge DeThomasis. Clear. Despite Mark Feather's physical absence at the January 23rd, 2024 hearing, he was certainly present in spirit and clearly at the forefront of things considered by the judge. From the first hearing on November 29th, when respondent was represented by Mark Feather, his misrepresentations to the court, which gained his client the first of many continuances, misrepresented why the continuance was necessary. The court relied on the misrepresentation. And then when the court asked for it following week, Mr. Feather was represented, who represented no objection to that date. And by the way, his back was turned and he had missed what the judge has said. There was no pushback, right? Because he didn't hear you. There was no judge, but I might have something. There was a no judge, but I might have something. And I point that out, says Judge DeThomasis, because I want it to be addressed to both counsel that, okay, so now I'm attacking Shochet and Feather is not here. And on November 29th, respondent was represented by Mark Feather, when offered an opportunity to reconvene the hearing the following morning at 9 a.m., made misrepresentations to the court, which gained his client the first of many continuances. Misrepresented why the continuance was necessary. The court relied on the misrepresentation and granted the continuance. And then when the court scheduled it the following weekend, Mr. Feather represented no objection to the following week. Totality of the circumstances, which I'll discuss at a relevant point here this morning. We're waiting, Your Honor. We're waiting. You're like, I will talk about it, but you never do. You just talk about talking about it, which I'll discuss at a relevant point here this morning, which we'll never get to. Day one was continued and offered to be continued the following morning, November 29th to November 30th. Well, the record reflects that the respondent got a continuance on November 29th, the first continuance based on misrepresentations to the court. What really becomes just in short, day one was continued, and despite offering to reconvene the following morning, November 29th to November 30th. Well, let's talk about context. Your co-counsel, current co-counsel to this day, Mr. Feather, Mark Feather, represented that he could complete the case in 15 minutes. 15-minute Mark Feather, your co-counsel, in violation of the Supreme Court Order SCAO 1122 and in violation of our Chief Judge's Administrative Order 1.14 version 2, despite that obtained unredacted copies of the 1129 and 12.6 proceedings, and is now answering to contempt charges from the Chief Judge, Mark Feather. 15 minutes, Mark Feather. When we revisit your need to take the deposition, your co-counsel said it could be done in 15 minutes to call two witnesses, possibly his own client, argue the case, and cross-examine, so that would leave, I'll be generous. And are you unnoticed that your co-counsel is already, Mark Feather, in violation of the Supreme Court order on prohibition against dissemination and our Chief Judge's 8th Circuit Court order? Are you? You know that your co-counsel, Mark Feather, is answering to the Chief Judge. You would have to, that would have been concluded yesterday, but your co-counsel, Mark Feather, was offered another continuance because he was unable to appear. And that'll happen next Monday. And just another side note of accommodation. So 3 hours were fruitful, despite your co-counsel, Mark Feather, despite the fact that your co-counsel, Mark Feather, needed 15-minute Mark Feather to conclude. It is abundantly clear. Abundantly clear. Oh, welcome. Is this a Nick Stero raid? What's up, Nick? Good day, Nicky. How's it going, buddy? It is abundantly clear. Thank you for the raid, brother. It is abundantly clear from the judge's own comments that he was troubled by things allegedly done by Mark Feather starting on November 29th, 2023, that as of January 23rd, 2024, he remains troubled, having repeatedly castigated Feather in the litany of derogatory references to him in a manner disguised as totality of the circumstances. The judge directed that hostility toward Shochet. For example, in discussing the many challenges that Shochet faced when taking the deposition of Preston, who was pro se at the time, the judge launched into cross-examination of Shochet, as further evidenced by his tone, body language, raised voice, and inappropriately aggressive demeanor. So, you're giving her advice? Do you agree that the deposition that was taken by video as opposed to just audio was proper or improper? Do you agree it's been broadcast on your client's YouTube channel? You have to answer that. By the way, I do a much more animated version of this on Megan's channel. I'm just not going to do it again. You have to answer that. Did you tell me, have you done anything and has it been successful? Would you agree they've been unsuccessful until today? But that being said, in the context of this rule of safeguarding, it's the attorney's responsibility. But now you know it's being posted on Judge DeThomas's interrogation of Shochet was that of a zealous advocate. Listen to that statement again. Judge DeThomas's interrogation of Shochet was that of a zealous advocate. He's literally representing Lynette at that point from the bench. Given that the judge had not treated attorney Shochet, and by the way, the reason I say that is because he does not treat Silverman. If he at least did not cherry pick that piece right there, if he was just as angry at Silverman, if he would have attacked Silverman the exact same way, be like, Josh Silverman, oh, Josh Silverman, you and your silver feathers like Mark Feather, Josh Silver Feathers, if he just had that tone with Josh as well, Josh Silverman, Lynette's attorney, this argument would fall apart immediately. But the problem is, again, he's cherry picking. Josh Silverman, yes, sir. How may I help you? I am listening very intently. And periods of time, he'll be like, oh, yes, sir. Yeah. He was writing. I think Megan caught this. He's writing. Interesting. Yes. Yes, Mr. Silverman. He's very quiet, very solemn, very somber, pays attention, listens. Yes. Yes, Mr. Silverman. Yes, he never interrupts him, save for maybe one time. He interrupts Silverman one time in the video that we watched, the 1 hour and 30-minute video of the January 23rd hearing. I think one time he interrupted Silverman, one time, as opposed to 25 times that he interrupted Shochet, Randy Shochet, and anytime he interrupts, Shochet. He's very aggressive. He's very aggressive with his demeanor. Very, very aggressive. I'm going to report this to a federal agency. You guys are so punny. I love you guys. Judge DeThomas's interrogation of Shochet was that of a zealous advocate, given that the judge had not treated attorney Shochet in such a manner in prior hearings, coupled with the fact that the judge had already recited Mark Feather perceived transgressions, multiple times at this point. It would certainly appear that the judge's extreme bias against Feather had now transferred onto Shochet. Now, a trial judge's conduct crosses the line of ostensible neutrality. Now we're getting into the law. Ostensible neutrality and impartiality when he becomes overly involved in a hearing. That's Department of Children and Families versus JJ. That's a protected name because it was a child. Florida 5th District. A trial judge's conduct, listen to this language again, crosses the line of ostensible neutrality and impartiality when that judge becomes overly involved in a hearing. Excessive participation by the trial judge, this is Gonzalez versus Mercy Hospital, excessive participation by the trial judge may amount to usurping the functions of counsel and be an abuse of discretion and latitude of the court in such respects, with resultant injury to the rights of a party or parties. A trial judge's failure to remain neutral during a proceeding is also a due process violation that requires reversal. That's Sparks. Now, Judge DeThomas's adversarial conduct towards attorney Shochet has created and exacerbated Hales's fear of not receiving a fair trial by Judge DeThomas. His comments were not merely expressions of dissatisfaction, as he calls them, but a running diatribe of facetious. I use that word all the time. I forgot how it's spelled. But a running diatribe of facetious ridicule and resentment, which almost always finds its way back to Mark Feather. And nonetheless, we have current counsel in a case who files a motion to continue 24 hours and 20 minutes before a case he knew he couldn't be prepared for. Okay, first of all, you also gave Jeremy's attorneys 24 hours to file a 50-page writ of prohibition. So you have no right to speak. Your right to speak on this and be frustrated with timelines has been officially revoked from you, Judge DeThomasis. But anyway, nonetheless, we have current counsel in a case who files a motion to continue 24 hours and 20 minutes before a case he knew he couldn't be prepared for, files another motion to continue, which would have been about the third motion to continue, if not the second, depending on how you look at it. When the record evidence establishes that the court accommodated current respondent's counsel when he needed a continuance, when he got into the case, knowing the case was scheduled, because he said he couldn't be prepared. And he came in as co-counsel, Mark Feather, to a lawyer who told this court on November 29th, somewhere between 4:50 p.m. and 5 p.m. Like, seriously, Judge? Quote, Judge, I only need about 15 more minutes to conclude the entirety of my case. I found that to be incredulous and the understatement of the morning. But he files something. Again, another filing by a Feather after hours. But instead, in relevant part as relates to today, Mr. Shochet, who is co-counsel to Mr. Feather, files a notice of appearance 24 hours and 20 minutes prior to commencement of hearing that was scheduled to conclude these proceedings on December 6th. And so for counsel, and this is concerning to the court, for counsel to describe the efforts of an attorney who steps in with a limited notice trying to address the issue of calendaring the event, it precludes potential violations of oaths of attorneys. What? It includes potential violations of oaths of attorneys. I don't know where the heck he's getting that from, but okay. Or attorney who is answering to the chief judge, who's not even here to defend himself, for violation of the injunction, which you, again, do not absolutely have not and will not be privy to, because he is answering to the chief. You are not, you're just talking about the injunction. Injunction, what's your function? But this implicates you, Mr. Shochet. Literally, the words coming out of his mouth. Admitted 58. Judge DeThomasis is a rogue. He literally is going full rogue. And you are saying, I need a continuance because I can't possibly be prepared, which, again, the court, again, accommodated for Mr. Hales. And Mr. Hales, as I mentioned earlier, hired an attorney he knew could not be prepared. Which, again, the court, again, accommodated for Mr. Hales, and Mr. Hales, as I mentioned earlier, hired an attorney he knew could not be prepared. He knew he had a calendar conflict or a time conflict to be prepared, and he was accommodated. I've got no regrets about that decision. It was in conformity with the law and in conformity with the circumstances. No less than 13 times during this 90-minute hearing, Judge DeThomasis brought up the same three issues he had with Attorney Feather from back in November, December 2023. That means on the average of approximately once every 7 minutes, Judge DeThomasis resurrected Mark Feather by name or by reference, then condemned him for either his purported misrepresentation on November 29th or his violations of the administrative orders of the Florida Supreme Court and the Chief Justice of the 8th Judicial Circuit, or for possibly understating the amount of time he needed to finish on November 29th. Again, ad hominem attack, tarring and feathering, straw man argument, anything to detract from the issues that actually Lynette is there to litigate. He refuses to listen. Importantly, Hales was present in the courtroom to witness personally the judge's repeated verbal assaults on one of his attorneys who wasn't even there to defend himself. His fear of not receiving a fair trial before Judge DeThomasis, in light of his obvious bias against Mark Feather, was objectively reasonable. And immediately following most of those demeaning references came the judge's criticism of Shochet, in which he referred to Shochet as Feather's co-counsel when addressing him before the judge, when the judge then impugned Shochet himself for having asked for a continuance on December 6th. Those remarks at once suggest that the judge deems Shochet guilty by association of some inchoate transgressions to be determined by this judge because of Attorney Feather, and treatment strongly suggests the judge's antipathy and indeed his bias has extended now to Shochet. And as shown by the video of this record, Judge DeThomasis' hostility towards counsel was not just evident in his words, but in his entire being, his indignant and sometimes sarcastic tone and voice inflections, his body language, and even his finger pointing, either at Shochet or audibly down onto his papers to punctuate what he is saying. A judge should disqualify him or herself, back to the law, in instances where the judge has a personal bias or prejudice concerning a party or a party's lawyer. That's Murphy v. Collins. Granting writ of prohibition where alleged characterizations of Murphy's counsel as engaging in ploys and having a history of filing late motions and blaming court staff by itself could have rendered Murphy's fear of bias a reasonable one, much like we have here. Now, Judge DeThomasis' attack on the memorandum of law drafted by attorney Inkeles ignored material facts to justify his condemnation of counsel. All right, so Judge DeThomasis came after Feather. He came after Shochet. Let's talk about how he comes after Doreen Inkeles. Even if Judge DeThomasis' bias was evident in I think this is an unfinished sentence. I think it's trying to say, even in Judge DeThomasis' bias, it was evident in the other attorneys. Although Hales' second motion for disqualification made no mention of the memorandum of law in support of respondent's motion for sanctions, including voluntary dismissal, which was presented to the court by Shochet, but drafted by Inkeles, whose name appears on it, Judge DeThomasis addressed the memorandum in paragraph 7F of his order. It is true, as alleged in the motion under review, that on January 23rd, 2024, the court also commented upon a proffered memorandum of law that was presented to the court by attorney Randall Shochet, submitted January 22nd, 2024, see docket entry 97, that in the court's view, unnecessarily, unprofessionally, and gratuitously criticized opposing counsel for filing a limited notice of appearance for the purpose of advancing argument to continue on behalf of the petitioner as counsel averred he had a conflict and could not and would not be able to serve as counsel in the event the court did not change the next scheduled hearing date from the January 26, 2024 date previously scheduled. As the record would indicate, the court did admonish respondent's counsel for presenting such an argument and in such a manner as the court also remarked and reminded Mr. Shochet that he, Mr. Shochet, filed his own notice of appearance 24 hours prior to an already scheduled hearing date scheduled for December 6, 2023. As a result, he advanced argument that he could not possibly be prepared and thus required a continuance, which was granted. The rhetorical and condescending language advanced in a filing labeled as a memorandum of law and which described as wholly unacceptable behavior of opposing counsel was in fact the same behavior previously exhibited by respondent's counsel. So there you go. He's now attacking poor Doreen for her writing, which he doesn't even call. It's a memorandum of law, but it's not a memorandum of law. I see it as an attack. On who? Your buddy, Silverman? We know what you're up to, buddy. We know what you're up to. It's no secret anymore. You're playing favorites. The memorandum of law consisted of 11 pages, with the first 8 pages devoted to Preston's discovery misconduct. The last 3 pages addressed the conduct of Preston's newly retained attorney before he even entered an appearance of record because he stopped properly noticed and scheduled depositions, including for a third-party witness he never intended to represent, from going forward when trial was scheduled a week away, failing to maintain anything about either Preston's discovery misconduct or that of the attorney in obstructing discovery, and without having even appeared in the case, let alone filed a motion for a protective order. Completely omitting Hales' argument concerning the obstruction of discovery, which is still pending before the court, but now the proceedings are frozen, from both his comments during the January 23rd hearing and from his order of February 14th, Judge DeThomasis created the appearance that Hales' counsel sought sanctions merely because a continuance was requested by Preston's lawyer, which is not the case. In criticizing what the judge called a, quote, memorandum of law, unquote, he cherry-picking. I think somebody's watching my videos. I cherry pick. I think somebody's watching my videos. His cherry picking reveals his strong antipathy towards Hales' counsel, but also his partiality towards Preston's new lawyer, who regularly appears before him. Again, notice how they haven't even used the word Silverman. They haven't even used, you know why? Because Doreen and Randy are Class A litigants and writers. Okay? They're Class A litigants and writers. They're not pointing they're not acting like Judge DeThomasis. This is all Silverman, him and Silverman. All they're saying, Preston's attorney, Lynette's attorney, petitioner's attorney. Because there are gentlemen and gentlewomen of the court and of society. His cherry picking reveals his strong antipathy towards Hales' counsel, but also his partiality towards Preston's new lawyer, who regularly appears before him. His name doesn't matter, judges of the Court of Appeals of the First District of Florida. You just need to know this is a lawyer who's representing the petitioner, who regularly appears before him. Therefore, he is cherry picking. He is choosing who he likes and who he doesn't like. He admonishes the ones he doesn't like, and he plays favorites to the ones he does like. Although his order calmly states that he admonished the attorney for such a filing, the audio-video record more accurately reflects a scathing attack upon reading the transmittal email to his judicial assistant, which attached to the memorandum, the judge stated. Attached here is the case law portion to go with the motion. The fact is, what's attached does not even contain a copy of a case. So it's not even a case law portion. It's styled as a memorandum of law, and no cases are attached, but some are cited. It is primarily an argument, and it's considered as such. It will certainly come up later regarding non-compliance with a directive regarding timing of filing documents, late filing additional argument. Part of the characterization in this argument, which at one time was called case law and really was not case law and is styled as a memorandum, including extreme argument, quite frankly, that describes in part the limited appearance of an attorney on behalf of a petitioner, but accurately today here on her behalf to argue for continuance. But we've got language in this quote memorandum of law, unquote, that states in relevant part the attorney for the petitioner, who really is just trying to address the issue of calendaring. And so for counsel, and this is concerning to the court, for counsel to describe the efforts of an attorney who steps in with a limited notice trying to address the issue of calendaring the event, we have an attorney calling that bad faith. Counsel to petitioner's new attorney stating that I can't be here that day, but I can be heard. We have an attorney calling that bad faith, willful disregard, abject interference. And let me ask you this. Why are there excerpts? I look at the filing again late last night, effectively the morning before the hearing, that appears to be excerpts of a depo, page 5, page 12, page 60. And it's clearly excerpts, and under in conformity with the rules 1.3, 12, and 310, a copy of a deposition may be filed only under certain circumstances in conformity with the rules of general practice and judicial administration 2.425, in conformity with 1.280G, which would require good cause and minimizing all sensitive information. By the way, there's a lot of shorthand in this last excerpt. I'm starting to suspect this portion was probably written closer to the morning. I can tell as a litigator myself and as someone who had to spend all night writing something. Now, luckily, I sometimes, rarely does it happen to me, because I, thank God, have judges who are reasonable and are not so rogue as Judge DeThomasis for the most part, 99% of the time when I litigate. But sometimes you run into a judge like this. But sometimes when you're spending all night writing or reading something, your brain starts to lag, and you start making little silly shorthand, shortcuts and whatnot. So please, again, like I said, don't hold anything against counsel. It is purely clear that this is just lack of sleep. We're getting closer and closer to the conclusion. So in addition to remarking that the memorandum of law was filed late last night when it was filed at 6:55 p.m. and that the memorandum engaged in name calling when it simply characterized improper conduct by Silverman, Judge DeThomasis has entirely neglected to mention that the factual portion of the memorandum detailing the actual misconduct was filed 2 days prior on Friday at 5:22, cherry-picking arguments, cherry-picking pages he wants to read, cherry-picking attorneys he wants to attack. I cherry pick. I'm telling you, just tattoo it across his forehead because that's exactly what he is and what he does. Which the judge also criticized because his oral directive that was never reduced to writing was stated to be 5 p.m., although Preston's new attorney filed his document at 8:12 p.m. Yet despite Preston's new attorney having filed his motion for continuance over 3 hours late, the judge heard that motion without comment. However, when Shochet mentioned that the issue complained of was the attorney's conduct before he was even in the case, Judge DeThomasis making it hard for me to ignore you. The totality of the circumstances and cumulative effect of the derogatory remarks from the judge, disparaging, criticizing, and finding fault with anything and everything said and done by Hales' attorneys, caused Jeremy Hales to have a well-founded fear of not receiving a fair trial before this judge. Given Judge DeThomasis' litany of harsh words directed at Hales' counsel and distortion of facts used to further condemn Hales' counsel, Hales' fear is indeed reasonable. That was argument number 3. Now let's talk about argument number 4. By the way, to those of you who are just joining us, don't forget to like this video, comment below, subscribe to the channel, hit that notification bell, and join on as a member as you're so inclined. Don't forget to hit that notification bell so that you know when new videos are premiered on this case and other cases. I'm going to be premiering a video of my associate's jury trial all the way to verdict. Very short trial. It actually lasted barely 2 hours, and that's going to be posted on my channel in the next few days. Also, now I think I'm allowed to say this. I think I'm allowed to say this, but I don't want to give away too much. But to those of you who know who Turtle Boy is, Aiden Kearney, I'm trying to get him on the channel again. This will be the 3rd interview that we've done. We did one in September last year. We did another one in October last year. Then he went to jail for 60 days. We're going to talk about that. And he's going to tell you this is about the Karen Reed case out of Massachusetts. And that is another topic for another day. But let's finish this first. So again, don't forget to like this video, comment below, subscribe to the channel so you don't miss anything. And if you have a question right there, super chats, I will read all of them. There's 91 of you that either join on as a member or have a question or simply supporting the channel. So I'm going to read all of them as soon as we're done here with this motion. We don't have a whole lot to go. So bear with me, stay with me. You guys are troopers. We're almost there. We're at the finish line. Judge DeThomasis' use of double standards violates due process. Employment of double standards on the part of the trial judge amounts to a violation of due process. That's O'Connell. Double standard in determining legal sufficiency. Now, although Preston first filed her pro se, meaning representing herself, cyberstalking injunction petition in September 2023, followed by a supplemental affidavit in October, her matter was set for a hearing only, with no injunction having been issued at that point. Somewhere between the hearings on November 29th, where Feather appeared, and the one on December 6th, where Shochet appeared, Preston filed a supplemental affidavit to her injunction petition on December 4th, as we all know by now, which we are in the process of going over. We're finishing the original on my channel. That is going to be probably tomorrow, if not Sunday. And then the supplemental is going to be the toughest because it's like 338 pages, you guys. I don't know. I may have to break it down into, I don't know how many videos, but maybe I'll try and do it in 2. My goal is to have a total of 3 videos. One is already done. It's on my channel. And, I'm going to try and we're talking 348 pages in 2 videos. I think it's doable. I think it's possible, but, we're going to go through that. This time, the judge entered the ex parte temporary injunction. Upon the initial filing of a sworn injunction petition under Section 746.0485, it is viewed by the court for legal sufficiency. Judge DeThomasis has stated, when the court receives a petition or a supplemental petition as a matter of law, the court must accept what's alleged in the petition as true, period, end of story. Why? Because the court must do so. There's no choice in that. So he cherry picks. Remember this phrase. I must accept the facts as true. But by the judge's description, one would believe he had no discretion in granting petitions involving legal sufficiency determinations. Preston's injunction petition was merely set for a hearing. The judge did not grant a temporary injunction until she filed her supplemental affidavit. It is noteworthy that in her supplemental affidavit, she specifically named Mark Feather in one of her allegations, which we'll get to on my channel. My girlfriend, by the way, Chandler Remington, shout out to you, babe. She has been literally going through the entire thing, and it's wild. It's wild. And I may have misspoke. My source is actually telling me the supplemental petition was filed in October. There is another supplemental affidavit. I don't have the. Do I have the? I don't think I have the December 4th supplemental filing. I do not have the supplemental filing, so maybe we can get our hands on that. By contrast, Hales' two prior motions to disqualify the judge, which are also reviewed for legal sufficiency and contained not only allegations recognized by controlling authority as meeting the standard for disqualification, but transcript excerpts of in-court proceedings. Well, Judge DeThomasis simply denied those outright. So again, double standard, cherry picking. Judge DeThomasis employed a hyper-technical review to Shochet's notices of video depositions that were served on Preston and a witness, John Cook, in an effort to foreclose his arguments to obtain discovery necessary to prepare his case. Shochet's notices were also served before Preston's attorney was involved, and several hours of her deposition were taken before he got involved. Not only did the judge permit Preston's attorney to make arguments to exclude discovery items and limit the taking of further depositions when the attorney had only filed a limited appearance to argue for a continuance and when no motion for protective order had been filed, Judge DeThomasis allowed Preston's attorney to argue about discovery. So even though, again, this is important. Why? Because, again, he's cherry picking. Judge DeThomasis is cherry picking. Anytime there's a moment for him to attack Silverman and to be like, no, you have entered your limited appearance. You're only here to argue for a continuance. Oh, you want to talk about discovery? No, you do not get to talk about discovery. I would say that's fair. He's treating both sides fairly, Judge DeThomasis is. But he's not doing that. He's doing the complete opposite. Oh, you're only here for a motion for continuance. Okay, so talk about the continuance only. I'm going to talk about discovery now. Oh, he's not allowed to do that. Well, go ahead anyway. I will listen. Because they're buddies. Because they're buddies. He's playing favorites. He allowed Preston's attorney, Silverman, to argue about discovery directed to a third-party witness whom the attorney did not represent. Shochet's notices of taking depositions included all information required by the rules, except that the actual name of the videographer did not appear in the notice as it was known. Nonetheless, the error was waived under the rule, as Preston did not object. She was pro se at the time, representing herself, and is held to the standard of a reasonably competent attorney, so say the rules. Judge DeThomasis, however, seized on the technical omission of the videographer's name in the notices, which was waived in any event, condemning it as a quote-unquote video deposition that was not in conformity with the rule, which then became the mantra throughout the rest of the proceeding, as well as being mentioned in the order. The judge's critical comments below on Hales' use of Preston's video deposition make it apparent that the judge disapproves of Hales' earning income from his YouTube program. When Shochet wanted to show the court some excerpts from Preston's deposition to make it clear why he needed additional time for Preston's deposition, Judge DeThomasis looked at him incredulously and said, "So, now you want to disseminate it in court, huh? A portion of the video?" On the other hand, when applying the rules of procedure to Preston's side of the case, the judge was not at all rigid or technical. Although Preston's attorney argued well beyond the scope of what his limited appearance allowed, the judge merely dismissed it by saying that it will be remedied when he files a notice of appearance, plenary, and the court will acknowledge it. And notwithstanding the no motion for protective order had been filed on Preston's behalf to limit or terminate further taking of her deposition, the judge stated he would not permit her to be deposed further, litigating from the bench. Again, there it is. Prejudgment and expression of bias directly against Hales. Okay, so we talked about Mark Feather, 15-minute Mark Feather. We talked about Randy. We talked about Doreen, Jeremy's three lawyers. Now let's talk about Jeremy Hales himself. Prejudgment and expression of bias by DeThomasis directly against Jeremy Hales. Judge DeThomasis, sua sponte, of his own accord, considered the standards set forth in the rule on protective orders, and then, on nothing more than speculation and allegation, denied Shochet the ability to conclude Preston's deposition. In doing so, he prejudged the issue and perhaps the case on summary basis. And having it published in a case involving cyberstalking that's now gone on since September, how is that now the consequences of disclosing that video on YouTube? Not bad faith or considered in a manner that would be reasonably considered or annoying or embarrassing or unreasonably oppressing the deponent. Is on video broadcast for the entire world to see? Oh, he says it himself. The whole world is watching. So he knows that the whole world is watching. Hashtag buckle up, Judge DeThomasis. That's reasonably caused embarrassment, humiliation, potential danger. At least there's allegations of that. As is clear, the judge impermissibly shifts the burden to Jeremy's side of the case with regard to continuation of Preston's deposition to establish why it should be allowed or continued, when the burden should have been on Preston had a motion for protective order even been filed on her behalf to show why it should not be allowed. In doing so, he prejudged the issue based on speculative potential for a problem and elevated the omission of the videographer's name in the notice to cast generalized negative aspersions on Hales' counsel. The court perceives the totality of the circumstances as increasing the potential for additional potential harassment and or violations of the rules of the court, increases possibility of violating terms of the injunction, the redaction process, the video deposition, notice. The video notice should have been in conformity and what appears to be a continuation of this behavior and arguably enhanced, increased behavior that is troubling to this court. Most importantly, the court's prejudgment denied due process to the Hales by prohibiting the continuation of Preston's deposition when she had not yet been questioned about her supplemental affidavit, which was what finally triggered a temporary injunction to issue. The following comments made by Judge DeThomasis reveal his bias against the Hales merely because of how he earns a living. The result of that is you got a video footage for your client to publish and to make money on. His main source of income is monetizing YouTube. I have tried YouTube and I failed miserably. Will Mr. Hales teach me how to use YouTube properly? Because I am unable to make a living on YouTube. That part I made up. Your client has now monetized the posting of unredacted court proceedings of November 29th and December 6th, resulting in, pause, a lot of collateral problems directly caused by them. So that another consequence of there being additional time. And now that I'm hearing this morning is that Depo has been provided on YouTube. Buckle up, Buttercup. And then regarding the judge's overbroad ruling on sequestration prohibiting unsworn parties and unsworn witnesses to discuss the case, on March 1, the court will start with conducting inquiry as to who spoke to who and will issue sanctions against inclusion. What does that mean? I'm going to punish Jeremy for speaking to people. For using his First Amendment right, I'm going to punish Jeremy. A judge's personal bias is a proper basis for disqualification. That comes from a case, Lido, Florida's Third Circuit, Third District Court of Appeals. When a judge has prejudged a case without allowing the opposing party to present argument, denying due process, and issuing gratuitous prejudicial remarks, disqualification may be warranted. That's Wargo v. Wargo. Wherefore, based on the foregoing, petitioner Jeremy B. Hales respectfully requests a writ of prohibition by you all, the First District of Florida Court of Appeals, to prohibit Judge Craig DeThomasis from continuing to preside over my case in Circuit Court, Levy County, case number 2023 DR 416, respectfully submitted by Doreen Inkeles. God bless you, woman. Counsel for respondent, Joshua Silverman, Christy Lopez, Mark Feather is CC'd here, and the Honorable Judge Craig C. DeThomasis, certificate of compliance that they complied with the rules. It's type volume, blah, 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 all standard stuff. That is the end of this document. Now, let me show you all the reply by the First Circuit Court of Appeals. Here it is. This is brand new stuff. This has literally been posted an hour ago. This has been received an hour ago or so. Well, now it's more than that. I don't want to mislead you guys. A few hours ago, or it has been received about 2 hours and 4 and 5 minutes ago. All right, Craig Foreman DeThomasis. Here we go. I shouldn't insult myself like that. That's an insult of the highest order. So here we are, the District Court of Appeal, First District, Tallahassee, Florida, March 1st. This is today's date. See? This is today's date, literally today. Acknowledgement of new case. They acknowledge, yes, we have received it. Remember, the case number was blank. Now we have a case number 1D 2024-0550. Jeremy B. Hales, petitioner, versus Lynette Preston, respondent. They write, the First District Court of Appeal has received a petition for writ of prohibition filed in this court, on March 1st, 2024. All the documents filed in this case must contain this court's case number. Per Administrative Order 23-1, petitioner must file a docketing statement, notice of appearance of counsel, docketing statement, within 20 days of the date of this acknowledgement notice. If pro se, petitioner may file a paper docketing statement by mail or electronic docketing statement via the Florida court's e-filing portal. If represented, petitioner's attorney must file the docketing statement via the portal. They have a special portal for this. A fillable form version of the docketing statement is available via the link on the Documents tab of the portal or on this court's website, which is all general information. It's all public. Opposing parties must file a docketing statement only if they seek to make amendments, corrections, or additions to petitioner's docketing statement. Now, this is the most beautiful part of all this. Guess who has been officially served? You see that? You see that language? Honorable, which I don't know. Again, I think dishonorable is more proper, but whatever. Formalities, bureaucratic BS. Craig Constantine DeThomasis has officially been served. You have been served, sir. That is directly from the First Circuit Court of Appeals in the First District of Florida. You have been served, sir. It is time to answer for your crimes. Judge grudge served. I like that. Or grudge judge. I was flipped him. Judge. Yeah, grudge judge. Hashtag grudge judge served. Hashtag buckle up. Honorable. It's right there. You can't make this stuff up. I'll even zoom in for you just so you guys can clip this, whatever you want to do with it. Look at this. Served. Here, I'll move myself up a little bit. Here we go. So you guys can clip this. Honorable Craig Constantine DeThomasis served. Hales, yeah. Hashtag grudge judge served. As of today. Now, of course, it's also served upon everybody else. Mark Feather, Doreen Inkeles, Christy Lopez, Joshua Silverman. I don't know why they didn't list. Oh, actually, I do know. I was going to say why they didn't list Randy Shochet. That's because Doreen was the only one who signed the writ. But obviously, he's still involved in the case. But Doreen, props to you. I mean, absolutely wonderful, magical written stuff. I mean, unbelievable. Unbelievable. This is the clerk, stamped March 1st, 2024. And of course, it has like all these rules. Notice to attorneys and parties, we do not need to go over this. This is just formalities. There's a bunch of pages of what they need to do, what they need to watch out for. There's no point in reading that. I'm telling you, there's nothing of value there. You can trust me when I say this. Otherwise, I would go over it with you. But it's just going to be boring. You guys are going to fall asleep, and it has nothing to do with anything that we need to know, learn about, or educate you on. Okay? So let's do... yes, exactly, MG Law. She did an excellent job on the red given the ridiculous time constraint. Couldn't agree more. All right, let's go through these super chats. You guys have questions? I hopefully have some answers. Elaine Hudgens, thank you so much for joining on as a member. Same goes for you, Kathy Bates. Thank you so much, as well as Beth Valles. The Beans, welcome to the channel. David Bro. It's not, I know it's not Briox. The AUX is always silent. David Bro. Thank you for the super sticker. Ella Pate Correa. Thank you so much for joining on as a member. Joanne C. JoJo's Adventures. Thank you as well for becoming a member of the channel. Same goes to you, Chris Gale. Thank you so much for joining on as a member. And thank you, Tracy Hartig, for the super sticker, as well as Jen. Thank you so much for the euros for the super sticker and your generosity. Rose Marie Cato, thank you so much for your generosity as well. And Wendy Hedger Wallace, thank you so much. Patricia, thank you. Janine Elmendorp, thank you very much. Then who else do we have here? Andre, your favorite French Canadian. That's a cool name. Thank you for joining on as a member. And also Jeff P, thank you for joining. And also to DG Bounty, as well as Kathy Mowry. And look at that, Mad Scientist. Has it really been that long? Mad Scientist is a staple. He's one of the mods, you guys. He's been a member of this channel for over a year and a half. A year and a half today. Tomorrow it's going to be over a year and a half. That's crazy to think about. September 2022 is when you joined. Like shortly after the Johnny Depp trial, you became a member. That's wild, man. Welcome to the channel. Sarah Dyson, also welcome. Thank you for being a member, joining on as a member. Frank Wachter. I think I remember you. Thank you, Frank. Thanks again. Sarah Dyson, thank you very much for the super sticker. And now let's get to the questions. Angela Edwards asks, I'm happy that you are in support with What the Hales. I have been a member of theirs for a long time. And thank you, Angela Edwards, for also supporting this channel. Gil Montano says it should have taken 15 minutes for Judge Grudge to recuse after the first one. And you know what? I agree with you. I 100% agree with you. Ruth Mobley, go Larry, the DUI guy, hashtag the DUI guy, hashtag what the hales, flood social media and that courtroom. Thank you, Ruth. Paige Woodard, thank you for the super sticker. Patrick W, I thought Lynette was petitioner and Jeremy was the respondent. Could you explain? I explained that in the very beginning. It's because now Jeremy is asking the court for something. Grudge judge will pay with karma, says Ilana Meineke. Thank you very much. Drive bags. It is marking feather. Margaret Tier, thank you very much. Richie Kavanaugh's song called Pheasant Plucker, playing in the background, I guess. Margaret Tier, it is a song about feathers. There we go. Kevin Robbins, if the writ is granted, would the injunction against Jeremy Hale be lifted? If the writ is granted, it's going to pass to another judge, and the other judge is going to decide what to do with the case. Obviously, listen to the merits. They may choose to lift a temporary injunction, probably not likely until they hear the merits. They would be afraid. Every judge is afraid to become a headline, okay? That's a fact. Judges are afraid to act until they have all the evidence before them and all the facts before them, because let's say, God forbid, he lifts the injunction, And then the next day, Jeremy goes and shoots Lynette in the face and kills her. Now, we know that's not going to happen, but the judge is afraid because he doesn't know. He doesn't know Jeremy's intention. He doesn't know Jeremy's state of mind. Clearly, in his mind, Lynette, has taken an injunction seeking a petition for injunction for stalking. So she wants a protective order against Jeremy, right? That's what the judge is going to know. So once the writ is granted, let's assuming that it is granted for a moment, if it is granted, the injunction would still be in place. The new judge, would listen to the evidence, hopefully. And once they listen to the evidence, they will decide whether or not to lift the temporary injunction or to make the temporary injunction into a permanent one. And basically saying, I grant you your petition, Ms. Lynette Preston. Jeremy Hale, you are to stay, away 500 feet minimum, blah, 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 blah. Maybe the equivalent of what he has in Ohio. Lynette could have something like that granted against Jeremy. Now, based on everything I'm learning, the chances of that happening are very low for a judge to look at all the evidence and say, but sometimes judges will err on the side of caution. And they're like, look, it doesn't cost me anything. So just to protect myself as the judge, and to protect this potential, person being harassed, some judges may simply go, to err on the side of caution, I'm just going to do like a minimal granting of it. Some judges are like that. Some judges are complete opposite. They are not afraid of becoming a headline. I think I've heard all the evidence. I think, Lynette, what you're putting before me is complete and utter nonsense, and I'm going to rule against you, and I'm denying your petition. I'm biased. That's what I would do, but I'm not afraid of becoming a headline. I'm not afraid of something happening as long as I feel I'm in the right. Again, as long as I feel that I'm in the right, if I have educated myself on all the facts, if I understand all the evidence, I am not afraid, because that's never going to happen. Because if something happens, then my hands are clean. I looked at all the evidence. I looked at all the facts. I listened to the testimony as a judge, if I were the judge on this case. And that's it. That's it. So we'll see. We'll see what the new judge will do, assuming, again, it will be granted. And I'm sure somebody in here asked if, what do you think are the chances of it being granted? So we'll probably get to that, get to those questions. Rich Atwood, get feathered. Exactly. Tobin T, in light of your feather pen, Lynette and DeThomasis should take note of Mark Twain's quote. Never pick a fight with people who buy ink by the barrel. Don't forget to like this video, comment below, subscribe to the channel, by the way. Hit that notification bell so you don't miss any future videos. And subscribe and join on as a member if you want. Subscribing is free. Joining on as a member starts at 99 cents a month. And if you have questions, now is the time. Now is the time. I'm going through them. I have about 70 more to go. So if you have questions, get those fingers typing. I will try and get to, not try, I will get to all of them, and I will try to do so as quickly as possible. Du mil vingt-quatre, I can't decide who is worse, Lynette or DeThomasis. I think Lynette is not as worse because DeThomasis also has power over other people. Lynette only has power over as far as this petition is concerned. Helen Gall says, just jumped out or from Megan's love you both. I love you too. Thank you so much. That was 2.5 hours ago that you sent this when she had. Oh, for Larry, my name's pronounced 2024. 2024. 2024. I'm going to try and remember that. You're going to hold me to this. Hold me to this. 2024. 2024. 2024. Okay. All right. I'm learning French. This is awesome because my girlfriend speaks French and all I know is every time she speaks French to me, I'm like, sacré bleu, because that's all I know. Oui, oui, je ne sais pas, Laurence. I don't know. That's all I know. The Bean says it is Hales, not Hale. Yeah. So if somebody in the chat was saying Hale, or if I accidentally said Hale, I apologize. Margaret Tier. Mark Feather defended Mrs. Silverman in her divorce. That's correct. Against Joshua Silverman, and grudge judge presided over it. Crazy. What a small world. Amrissa Loftus. I mean, small county, small town. We get it. Amrisa Loftus says, did this judge even learn how to be a judge before? It feels like doesn't even know how to a judge works. I agree. He's barely been a judge for a few years, and most of them were COVID years. So now he's finally being outed for his misdeeds and deprivation of constitutional rights of others. Mike D, thank you for the pounds from somewhere in the UK. Great coverage and support for the Hales. Thanks for breaking down the laws and the rules. You're more than welcome. Thank you for your support of the channel. Navy Vet for the broken. Navy Vet love for the broken. Thank you so much. What upsets me, he says, is so many of us took an oath to protect and defend the Constitution against all enemies, foreign and domestic, and this judge included. Buckle up, grudge judge. We're coming for you. Exactly. Jennifer W. Lynette didn't even sign her petition. This case is null and void. Well, she didn't sign one portion of it. She did sign the initial portion, but you're absolutely right. Mandy Penwell, I think he wants 15 minutes of Netflix or A&E, which he is absolutely going to get. He's not going to like it, but he's going to get it. Free Charlie says, how come you aligned with Chile de Castro? Numerous restraining orders for stalking and beating women. I don't align myself with Chile de Castro. We are temporarily aligned in interests, but I don't know. I think he's a decent dude from what I know, as far as I know, and I know this much. I know 1% about Chile. He also, like me, we're aligned in our dislike and disgust for corrupt police officers. That is the only thing I agree with him on, just for the record. Okay, since you asked, I wasn't going to bring this up because I don't think it's relevant to this video, but since you asked and you're interested, I am purely aligned with him for on the temporary basis because we both hate cops who don't follow the law. That's it. And he's helping Craig Hendry, who's on my channel, set for trial on May 1st, 2 months from now exactly, in Boyd County, Kentucky. There's going to be much, much more to come on that. But I don't know him personally. And look, even Craig Hendry, I hear things, people tell me things. I get it. He may not be the most ideal, number one plaintiff type person in the universe. But I don't care about their personalities. I care about protecting people's rights. You know what I mean? Even the scumbaggiest of the scumbaggiest of the scumbaggiest people on the planet, if their rights they're being deprived of their First Amendment right, if we decide to say, you know what, they deserve to rot and we're going to ignore the fact that their constitutional violations are going to be violated, guess who's next? You are. And when you're going to say, well, wait, I'm different than that scumbag. Why am I being treated this way? Well, why should you get preferential treatment? How are you different? You didn't mind when we were trampling on his constitutional rights or her constitutional rights, and now you're up in arms because your constitutional rights are being trampled? No, we do not cherry pick. We do not play favorites. We defend the Constitution at all costs. We are the gatekeepers of the Constitution, you and I. Okay? And the Hales included. The Hales included. Juliet Morgan, I have been worried from day one when I saw the videos. I've been with What the Hales for a very long time. Thank you so much. Tina Marie, 1989. I don't know if you know this, victim advocate Amanda Martins. Yes, I do. Yes, I do. Husband is a law enforcement officer in Levy County. Hashtag buckle up. Yes, I'm aware of all of that. Thank you for the tips. Very important stuff here. Willie Borzash says, could the higher up investigate grudge judge past cases he ruled on to see if he has a pattern of misconduct? Absolutely. Absolutely, Willie. Absolutely. He's the hanging judge, says Rick M. Charlie Lynn says the narcissist vibes are strong with grudge judge. You, sir, a highly esteemed member of the court, must follow the rules. Don't be a dictator. Exactly. Ginger Grivoy. Hopefully they will deal with this sooner rather than later. Thank you very much for your donation. Nadia Beeswax. I really hope that Mark Feather is watching this and having a good laugh. I hope so too. Deborah Kennedy, thank you for your generosity. Same goes for you, Richard Miller. Chi-Town Legal, thank you for all of this. The Hales are wonderful people. God bless you. And God bless you too for supporting the channel. Carolyn B says, I love all the voices. It's reminding me of the Jetsons. Well, maybe. 2024. Fuck. 2024. 2024. I think I got it. 2024. 2024. Check out the robing room again. The ratings have gone up. Yeah, because of course, all of Lynette's homies are bringing his rating up. At least the video is forever memorialized before the changes were made. So I will take that as free publicity for our channel and our cause. Denise Ricard, judge should be locked up in a chicken coop. Maybe that's what he deserves. Polly Bailey, I hope judges read it with the same energy as DUI guys. So when I had that little rift of reading Judge DeThomasis's words, I hope the judges in the Court of Appeals also read it with the same energy. She says. Okay, more green tea. I hope, yeah. Pepper NC says that you deserve an Academy Award. Thank you. I will take that. Somebody call the Oscars. The DUI guy is paying you a visit. Lynette Nielsen. Lynette hairspray is when your lies need help holding up in court. That's funny. That's a good product to create. Lynette hairspray when your lies need standing up in court. The Floofy Cat, welcome back. Judge had a little grudge with the lawyer Feather, and every time the lawyer spoke, Judge would say whatever. I love it. I love that little rhyme. Hashtag grudge judge, hashtag buckle up. Hashtag buckle up, Buttercup, says Steve Kellums. Alan Beaulieu, with my big red nose, can I get a job in the clown court? You know, I think you might. I think you might be able to take the judge's position at this rate. Roz Marie Cato, thanks again for the 50 secs. I love saying that. I love when you are theatrical in the way you explain the law. Thank you so much. I hope they take this judge away from the case and the Hales gets their life back. Thank you very, very much for your support. Gone to text. This reminds me of the movie The Caine Mutiny. Caine Mutiny. I don't think I've seen that movie. I might have to watch that. Rinky's Carnage Crew says, Larry, I'm not sure if you have done enough research to understand Jeremy wanted this case to go forward in the beginning for countersuing purposes. No doubt. I have absolutely no doubt. Scott Gowan, grudge DeThomasis, stop trying to find love in the courtroom with Lynette. Sam Hobbs, can the DCA, the Court of Appeals, dismiss the case or just remove Judge D? So what they're probably going to do is they're going to remove him from the case. They're not going to dismiss the case. No, they don't have that kind of power, and they're not being asked. I mean, they do have that kind of power. I shouldn't say that. They're not being asked to do that. They're only going to do what they're being asked to do. Is that a troll? Free Craig? Who would want to free Craig? No, put him in a cage and throw away the key. What the hell? I think we got a troll in the chat, folks. Attack! I'm just kidding. Can the DCA? Yes. So no, they can't dismiss the case. They're only going to do what they're being asked to do. Vicky says, if the judge ends up 100% removed, can old cases be reopened due to his illegal actions? Maybe. Maybe. We shall see. Keith Jones asks, is there no writ that can be sought to stay the injunction against Jeremy under the circumstances? I know habeas corpus is inappropriate. That is correct. It is... oh, hello. Is Hendry in the chat? I didn't see him. If you're in the chat, buddies, shout it out. I'll highlight you and promote your channel because you got some good stuff on there. But I don't see it. I don't see you. Anyway, Jeremy wants his side of what really happened. Exactly. Keith Jones says, is there no writ that can be sought to stay the injunction against Jeremy under the circumstances? Yes, but it's probably fruitless because, again, we need to focus on the main event. The main event is to remove the judge from the case, period. Remove the judge from the case, period. And then later remove him from all cases, period. And you're right, habeas corpus is not, because Jeremy is not incarcerated. Thank God. Although he could have been. Michael L. says, the order resulted from Lynette's lie about macaroni. Grace Washburn, thank you for the super sticker. Rinky's Carnage Crew, one more question for you. Can Lynette Preston's attorney, be liable for Jeremy's lawyer fees, or just Lynette Preston? That's a great question. Here's how I'm going to answer that. You can probably include him in the lawsuit, but his liability would be so minimal, it wouldn't make any sense to include him. I mean, you can still include him, and he'll be liable for, I don't know, let's say 5%. Assuming, again, Jeremy wins, because you can't sue the judge, absolute immunity. We're going to talk about that in a future video. I already have the thumbnail ready. If you guys want a sneak peek, actually, you know what? No sneak peek. I'm going to keep it under wraps. I'm going to keep it a secret. I'm going to keep it a secret because I already have the thumbnail for it, but I'll probably make the video on that later tonight or tomorrow or Sunday, because we also have to cover a bunch of Lynette's stuff that has not yet been done, because we only covered about 40 pages of the first petition. Now we also have the supplemental, and then there's a second injunction of the supplemental injunction, and there's just so much stuff. And my girlfriend, who's gone through it, God bless her, Remy Legal, by the way, follow Remy Legal on both Twitter and YouTube. She said a lot of it is just so repetitive. It gets so exhausting to go through, and a lot of the messages, Lynette just like literally screenshots Facebook messages and prints them off and then calls this evidence. And these messages have nothing to do, as you will see, nothing to do with Jeremy, nothing to do with her. They're just calling her out. And she's like, I don't like this. I don't like being called out. Jeremy should be restrained from contacting me. It's like, this is not even Jeremy doing this, you idiot. So again, I would go after Lynette and everything she's got, which is not much, after Jeremy wins, because going after the judge is impossible unless he's removed and absolute immunity may be lifted at some point. I mean, we're talking some very complicated, very little precedented stuff. Not a whole lot of precedent on that stuff. Carolyn B, thank you so much. She says, so much coming from What the Hales' lawyers that have more information than what has been shared by What the Hales, all legal steps and terms. So much coming from What the Hales' lawyers that have more information. Yes, yep. Of course. I mean, the lawyers are going to have all the stuff, right? Q, have some tears of opposing counsel on me. Hey, I appreciate that, Q. I love you, man. He's been a staple, by the way. Can I just shout you out, Q? You've been a staple on this channel for as long as I can remember. Even before the Johnny Depp stuff, I'm pretty sure you were around. Even when I used to do like, hello, everybody, and like 100 people in the chat. You know, today we almost had 10,000 people in here when I was counting. Now we're about 4,400 of you. You were here when I had like 100 people, when my channel was like super duper young, and I only had like maybe, I don't know, 180 people. You're a real G. Welcome back. So good to see you back on the channel. I meant Judge Grudge is the BAW mindset, not you. Hey Joe. BAW. Sorry, you lost me. I'm lost a little bit, but it's okay. You don't have to clarify. I got you. Everything is good. Greta Fortenberry. Larry, to watch you when you are thinking about the law, you seem to be in such deep thought. You're a great attorney. You are too kind. Thank you. That is, oh my God, that makes me melt a little bit. Thank you. I do love the law. I love what I do. This is just who I am as a person. I mean, you get to see the real me. And if you watch my courtroom work, you know that that's just how I roll. I don't know how to be not me, you know? Kathy Mowry. Thank you, Larry, for all you're doing for the Haleses. You rock. Thank you very much. The movie JW, Victim Suspect, Believe Women and Examine. Yeah, believe all women is a terrifying phrase. Believe the truth, believe evidence, believe facts, believe some women. I will agree. But if the most dangerous thing you can possibly do, it's like, think about it. If we were to apply believe all women, then Lynette's petition should be granted without even looking at the evidence. And look at what we have. We have so much evidence to support Jeremy. Her petition would just be automatically, magically granted. Believe all women. Oh, Lynette is a woman. Believe all women is the mantra. Therefore, A plus B equals, but petition for stalking should be granted. Jeremy, you are guilty of stalking. The fuck? No. Alliterations and puns. Exactly, Charlie. That's the words I was looking for. Kevin Cotter says, do not skip 14th Amendment due process clause. Yes, that's the one that is applied to all 50 states through the 14th. That's how you apply all the amendments to the states. I think you're taking me back to law school. I don't do this shit. I don't litigate this shit, but you're absolutely right. David Bro, the feather wants a scalp. Jay Selman, Jays, you should hit up Jeremy when you get to Florida for some barbecues. Hell yeah. Debbie Minton, your girlfriend will learn a lot from this case. I'm sure she would. Oh, yes. And she will. And she is. Fluffy Twinklebutt. That's a hell of a name. Sunshine is the world's greatest disinfectant. You turn on the lights and the cockroaches scatter. Hashtag buckle up. Exactly. Dwayne Norvell, mom died. Her mom didn't die. Proves she's a liar. She just doesn't know how to keep the truth straight, right? Diana Bullock, I believe you're right. He's trying to make Jeremy bleed money and mental health. This is so cruel in so many ways. Stay strong, Jeremy and George. Sending hugs. Likewise. Karen Karsten, Judge Grudge needs a safe space because words hurt, don't they? And they take away people's rights when you're on the bench. Constitutional freedom fighter, a redacted version could be a blurred section and still be the exact same length. You would have to watch both to see if there are any actual differences. I absolutely agree. Michelle Natali, can his previous ruling on all cases be reviewed? Very possible. Yes. Kudos, Larry, on your puff puff pass skit. Thank you. JW, this case is the epitome of transparency being everything. Love that people are on it. Proud of us for watching. Absolutely. This is the people coming together. Denise Ricard. Larry, just to make you smile, here's a dad joke for you. Why did Beethoven get rid of his chickens? Because it kept saying, bark, 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 bark. I guess Mozart didn't really like it either, did he? Neither did Chopin. Which, by the way, did you know that both the French and the Poles argue about whether Chopin was French or Polish? Fun little fact for you. When I went to visit, I was in Poland and I was in France, and my tour guide was like, the Poles claim him because his mother was Polish and his father was French, or his mother was French, his father was Polish. Yeah, I was like, okay. There's a statue to Chopin in Warsaw that was destroyed by the Nazis and then later redone and recreated from memory and I believe maybe a cast, which was really cool. And then there's also the school where Chopin studied, I believe, where he studied music. And it's really funny because here's another little funny fun tidbit. Is Chopin actually would like to go into closed rooms and be like complete darkness, you couldn't see anything. And he would literally just like he said he could hear the music in his head. I mean, he was a musical genius, absolute musical genius. Jeffrey Montgomery says, you and Megan should compete. Oh, competition? Who can read the judge's responses faster and with fewer errors? Winner gets 20 subscriptions to their channel. That's an idea, I suppose. Sounds like a fun. I love healthy competitions. Sarah Dyson, thank you so much for the 20. Debbie Childers, welcome back. Can't wait to see the Hales win. I agree. Neither of us can wait. Is not Judge DeThomas's court more like a kangaroo court, Dulkurth? Exactly. It's a kangaroo court. It is literally turned into a kangaroo court. DJ Radis is asking. Oh, so DJ Radis is the one who created this a few videos, and I'm gonna play that video. Maybe not in this video, but I'm gonna play that video that you made of me, which I thought was so fucking hilarious. It's terrifying that you can use AI to, like, recreate a person's voice these days, but that's not news. That's already been around. Just no one has ever recreated my voice before, and it's kind of freaky. But at the same time, it's really freaking cool because it's like, whoa, you're listening to it and you're like, this is dope. Like, because it sounds real, as close to the real thing as you can. And I give you 10 out of 10 on the recreation of my voice. I don't know how you did it. Maybe I don't even want to know. But you said, can I use your judge's impression in this? So absolutely, man. The internet. This is what I love about the internet, by the way. And I'll say this. This is my own personal First Amendment spiel. Okay, just for a second. I myself, when I started this YouTube channel, I freely admit I was a copyright cuck, because somebody would like use my stuff and I'd be like, this is my stuff. Why are you taking my stuff? Why are you monetizing my stuff? Little did I know, they're just giving me free publicity. Why do I care? They're making crumbs, compared to what I'm making on the YouTubes. So what the hell do I care? Now I say the more the merrier. If you want to use my stuff, if you want to clip that, the portion of me doing the reading of the judge and turn it into something more, turn it into a song, turn it into a short, turn it into a little clip. You want to post it on your Facebook, your X, your Instagram, your YouTube, your Twitter, your whatever. I think I said Facebook, LinkedIn, what other social media platforms we have out there? Threads, which I don't use. What do I care? What do I care? To the contrary, first of all, I think if you think it's funny and you think it's going to make people laugh and it's going to entertain people, I have no problem with it. Clip it. I will never, as long as I live, unless you're just plainly stealing content, plainly just copy and paste, no commentary, even that I may let slide. But if I see that you are just openly, blatantly ripping me off, I mean, I'm going to take action. I think that's anybody in that position will take action. But if you're providing commentary, if you're turning it into something fun, if you're turning it into something entertaining, if you're turning it into, or you're just clipping it and you want to show the world and watch this clip, there's a lot of clip channels out there. I will never copyright strike a clip channel, a channel that is literally designed for taking these. What are we at now? 3 hour, 5. Who's gonna sit there for 3 hours and 5 minutes? You want to show them the one bit where DUI guy made a fool of himself and he was an idiot and stupid and funny or whatever, and look, point the finger or be like, look, he was hilarious here. What do I care? Go for it. Go for it. This is what the internet is for. This is why I can turn off that camera right now and never, if I didn't want to, and just never appear on my channel again. I could do that right now, but why would I? That would be the way to stop it, right? That would be a way to stop me stop you from clipping me, is by not providing any content in the first place. But clearly, there was like 10,000 of you at one point today. Clearly, you're liking something, so I'm just going to keep it going. So to answer your question, this is my lawyerly 10-minute response to a 5-word question. Can I use your judge's impression in a song? Absolutely. Absolutely. And thank you for your support, by the way. Risa Murphy. What about George not being able to carry arms? DeThomasis is violating her rights with a temporary injunction on Jeremy. Exactly. Exactly. What about her? We're forgetting about her. Kate says, shouldn't they point out that Judge DeThomasis refuses to acknowledge and enforce the CPO from Ohio against Lynette Preston and John Cook? No, that's not the point of this writ. Excuse me. The point of this writ is to remove Judge DeThomasis from this case. Period. The end. Andrew Oakley, what does the served actually mean? It means he received a copy and he's aware. Mary Kay, welcome. Thank you for joining on as a member. Also, oh wow, we have a lot of new members. Thank you, Angela, for not only joining on as a new member, but also gifting 5 memberships. Shout out in the chat if you got a membership from Angela. Thank you so much. Cappy Cross, also welcome to the channel, as well as Anna Branch and Kate. Kate decided to join. Thank you. And Private C Private also. Thank you for joining on as a member, as well as Roy Lonsinger. Thank you for joining on as a member. Let's get back to the questions. Timothy J. Tanner says, judge was berating use of Depo on YouTube, and he may have forced Jeremy to break privilege by forcing him to answer questions relating if lawyers talked about if he should post videos. Exactly. Literally, the judge is complaining about, a breach of attorney-client confidentiality, and meanwhile, he's like, answer for your crimes, Jeremy. This is so weird. This is absolutely so weird. Pickled Tink says, who thinks that Josh Silverman will drop and run on Lynette since his buddy, the judge, is no longer presiding over his case, especially since I'm sure that 7,000 is long gone by now? It's a good question, Pickled Tink. What do you guys think? What do you think is going to happen? Crystal Paranormally says, hashtag 15-minute mark. Thank you for all that you do. Thank you so much. And thank you for your generosity and support of the channel. Also, before I forget, I want to speed chat up a little bit because you all have been so good. I want to allow you guys, if you want to comment, if you want to ask questions, etc., let me go ahead and speed you guys up just a little bit. Here we go. Customization. We'll make it double the speed. How about that? Here we go. I'll speed you guys up from 60 seconds. It is now 30 seconds. Hashtag buckle up, buttercup. I should probably, while I'm doing these videos, I might even... How about this? Hashtag buckle up. I'm just going to keep it down there. I think that's a little bit smarter. Hashtag buckle up. There we go. Mark Millen, we need a meme of Judge Craig DeThomasis working at a McDonald's drive-thru. Get on it, chat. If anyone is capable of it, it is you. Sasha Benoit says, isn't it super inappropriate for the judge to look up or watch anything regarding this case, just like jurors are ordered not to look up or watch anything? Not really, because jurors are in a special position. Judges are a little different. I agree with you that that's the way it should be. Sasha Benoit, that's a fantastic question, as a matter of fact. The problem is judges have been determined by the Supreme Court of the United States that they are, because of their legal mind capacity and the place that they're sitting at the bench, they're able to take the facts which are relevant to the case and take the facts which are not relevant to the case. And they can absorb both of them, swallow it, chew it, whatever, regurgitate it, and then be like, well, I am not going to pay attention to this because it is extraneous information, even though it's in their head. But this is important, so I'm going to keep it front and center. It's complete and utter horse shit, but that's how our legal system works, because bias is real, as we obviously can see from this case. Bias, prejudice is real. Kontiki Bay says, why doesn't the court enforce the Ohio order? Fantastic question. Your guess is as good as mine. Under federal law, they must. I agree. Under Section 2265, I don't understand why they refuse to do so. You know that meme? That's the answer. Oh, I agree. Oh, Chris Solke. I've been a follower of What the Hales for several years, and I'm glad the YouTube community is standing up with Jeremy. Absolutely, Chris. You got that right. Rebaw54, thank you very much for your generosity. Navy Vet for the Broken. My apologies. I'm not a sir. I'm a female. LOL. Served at the end of Vietnam. Thank you for serving. And I apologize for misgendering you. I didn't see a photo. So, see, if I had looked at it closer, there it is. United States Navy woman veteran. See, sometimes I have to open my eyes, but the problem is your text is like literally this big on my screen. So that's my defense. That's my defense. I do apologize, ma'am. Thanks for serving. Kirkindall Mom, love What the Hales. Thank you for the insight. Thank you for your generosity and support of the channel. Joanne Wall, you are such a goodie. Found you through What the Hales, but I've watched some of your older videos. Oh, thank you. Yeah, I have tons. I have like almost 1,500 videos on my channel of all sorts: shorts, long videos, interviews, lots of stuff. Johnny Depp stuff, behind the scenes of Johnny Depp stuff. You know, I was there. I was in Virginia during the Johnny Depp trial. For those of you who don't know, check it out. I have an entire playlist devoted to me reading all those motions. I have so much content on my channel. I read Curious George once upon a time. I have like 5 or 6 videos in that playlist. If you want a laugh, watch my Curious George series. Robo770 says, the appeals court judges will have known this was coming, and I've been watching you for the last few days. Us, hashtag buckle up, hashtag DUI guy states the law without bias or prejudice. Matt Red Queen says, hope Superior Court watched unredacted videos and removes judge, then moves case forward fast. I agree. If the judge is dismissed from the position of judge, can he be sued for his behavior? No. Absolute immunity. We will talk about it. This is a recurring question. And I will... I will do a separate video on it, maybe even today. We'll see. Maybe today, if not today, then tomorrow. It's basically on absolute immunity. Judges, prosecutors have absolute immunity. What does it mean? It'll be a short, quick video. It won't be long. Maybe I always say that. And then my 20-minute video the other day on Wednesday literally turned into almost a 2-hour video. So it is what it is. Paul Amos says, if the judge is dismissed from the position of judge, can he be sued for his behavior? I think I just answered that. Sorry. Micheline McWilliams. Micheline McWilliams, thank you for the super sticker. Pepper, North Carolina. What the Hells will have Mr. Feather on his channel tomorrow. Ooh. Mr. Feather is going to join since he's no longer attorney of record. That's cool. Go subscribe to them. Go check that out. That sounds fun. I'm going to be there too, hopefully, depending on what I have going on. Do you know what time? Do you guys know what time? You already covered absolute immunity in the canons. I mean, I did, but I didn't cover it exactly. It was just a one sentence. There's more to it. There's more to it, James Bradley Stanley. I thank you for being awesome. Enjoy your coffee. Thank you very much. Hashtag buckle up. Buttercup. World Explorer. The world says, Judge, you've been knocked down by a feather. Wow. You can't make this shit up, folks. This is glory. This is genius. This is genius. Judge, you've been knocked. Somebody turned that into a meme, like a judge being knocked down by a feather. That's so brilliant. Andrew Oagley, you have made this so easy to follow. You're welcome, Andrew. Thank you so much for your generosity. Debbie Childers, there has been a new adjudication. A new adjudication? When, where, why, how? Does not compute. Can you please clarify? We're on our way to 400K. Hashtag buckle up. We're getting close. We're seriously getting very, very dangerously close to 400,000 subscribers. We're already, where are we at? We just crossed 385,000. Well, look at that. Wow. Just climbing up the ladder. Like it's absolutely crazy, you guys. I love you all so much. This is insane. Wow. I didn't even see that. I will take it. Hey, when you do good work for good people support you. That's just the way it works. It's just the way it works. And to think, literally, I just want to show you guys this. I want to take a quick segue. All right. I think I'm allowed to toot my own horn. Don't you agree? I think I've earned the privilege after providing all this content to you all. Since you've asked, We were at 360,000 subscribers. Look at the date on this. February 21st, 2024. This was literally a week ago. 1 week ago, we were at 360. February 21st. Now, then February 23rd, look at that. February 23rd, 2 days later, we were 365. 2 days. It took 5,000. 2 days, 5,000 subscribers. Before that, look at this. Before that, it took me like, I don't know, a month. It took me a month to get from 355 to get to 360. Before that, 350 to 355 was like 3 months. But that's because I wasn't really creating content. Like November, December, January, we won't go there. But November, December, January, I wasn't really creating content. So it took like 3 months to get 5,000 subscribers. And then look at this. From 360 a week ago, 365, 370 on the 25th, 375 the next day on the 20th. This is all you guys. I'm just providing content. 380 yesterday and 385 today. I mean, this is madness. It's literally 5,000 a day for the last like few days. 5,000 subscribers per day. I've never seen numbers like this. It's unbelievable. You guys are incredible. You guys are absolutely bloody incredible. Thank you so much for your support. Okay, back to your questions. Back to the super chats. So there has been a new adjudication. What is that about? There has been a new adjudication. Yeah, and thanks to What the Hales is. I mean, are you kidding? This is all you guys. This is all you. And the What the Hales have been absolutely instrumental. I'll give credit where credit is due. 100 times out of 100. Even MG Law it got like 2,000 subscribers since last night. I mean, this is incredible. Good people supporting good people get good results. So I want to know what the new adjudication is, if anybody can fill me in. Andrew Oagley also joined on as a member. So did Pickled Tink. You guys are amazing. Thank you so much. And look at that. The Beans gifted 5 memberships to you all. Thank you so much. Thank you, thank you, thank you. Notice this just in Judge Nuck by... Okay, now you guys are trolling me. Judge did... Clara Kershaw, come on. Quit. Jennifer Whitaker, can a judge deny the stay when it is about him? Yeah, he already did. On Wednesday, Randy made an argument to freeze proceedings. Judge said no, unless he files the writ immediately within 24 hours, which he did. And now proceedings are frozen. They're stayed. That's what's happening. Woody Rowley, Christopher Lloyd can play grudge judge in the movie version. He would make a good grudge judge, Christopher Lloyd. I had to see his face. Yeah, he would play a good one, I think. Kimberly Mogan sent you some on fun in Messenger. Okay, I'll check it out. Thank you. Aries Hexam, isn't it a conflict of interest for Silverman to appear before DeThomasis because of their personal relationship? I mean, look, just because you have a prior relationship with someone who's currently on the bench, and I don't mean like sexual, although we don't know. If you have like a business relationship with someone, there's nothing wrong with you appearing before them as long as there is an understanding about any potential conflicts. But because it's such a small town, they're like, we do what we want and good luck, good luck. Michael Harris, thank you for joining on as a YouTube member. And look at that, the Angry Vet gifting 10. Shout out to you all. Who are one of the 10 that got a membership? Shout it out in the chat. Don't be afraid. Larry David would also make a good grudge judge. I agree. Christopher Lloyd and Larry David are both, I think, would make an excellent DeThomasis, would play an excellent DeThomasis in the movie. No question about it. Lady Tammy, Mark Feather will be on What the Hell's Live on March 8th, next week. March 8th at 8. Somebody said tomorrow. Okay, I don't know. You guys know this stuff. I don't know. I'm not gonna butt into things that I don't know. I only speak facts. So if you're saying it's March, if it's tomorrow, it's tomorrow. If it's March 8th, it's March 8th. I don't know. I don't know. Kirby Johnson says, John Cook is also watching your videos. He put out a video yesterday showing and talking about his property and the turtles. Because I mentioned that, right? His voice sounds like the bar complaint phone call. I listened to his voice. I don't think that's him. He's not that eloquent. John Cook is not that eloquent. He's not that eloquent. So I don't think it's him. I don't think it's him. But buckle up either way, regardless. So they posted their video about an hour ago. Let's see. So we finished the writ. We finished the acknowledgement. I mean, there are a couple of other motions that were filed. Not motions. They're kind of like attachments to it. We don't need to go through it. They're just exhibits. They're just exhibits. Docketing statements, notice of appearance. Again, it's boring stuff. I don't want to bore you guys. All I want to do is share the wealth, and just sharing the documents for no reason is not going to do us any good. It's just going to waste time. You guys are going to be like, why are we going over this? This is stupid. And I will agree with you. So I don't think there's anything else of value. Although there is one thing. Hold on. There is one thing. What is this? This was filed this morning by Doreen Inkeles. You know what? I will share this one because this one I think is actually interesting. And it's one page, so it's going to be really, really quick. Let's do that before we sign off. You guys ready? This one is good. So another one filed at 5:55 this morning in the District Court of Appeals of the State of Florida, 1st District. Again, why is this flipped? I already told you. I will repeat myself. Jeremy Hales is now the petitioner because he's the one asking the Florida 1st District, please remove Judge DeThomasis from the bench. And Lynette would have to argue, no. Please keep the judge on. I like the judge. That's why she is the respondent, right? He's in my favor. He's been litigating for me. He's been doing all these things for me. You know, she has no reason to remove the judge. So this is a motion for order to show cause. Show cause means like show cause to do something, right? And there's still no case number because this was filed at 5:55 in the morning. Motion for order to show cause. Pursuant to Rule 9.1 of Florida Rules of Appellate Procedure, petitioner Jeremy Hales requests issuance of an order to show cause. The final hearing that was set for March 1st today has been continued with a date to be determined. Good cause exists for this court to issue a show cause order because of the intolerable adversarial atmosphere Judge DeThomasis has engendered as set forth in the petition for writ of prohibition. Pursuant to that rule, petitioner seeks a writ of prohibition prohibiting Judge Craig DeThomasis from further participating in Levy County Circuit Court. Hold on a second, folks. Hold on a second. Unless I'm missing something, is this an order or a request for an order from the Florida Court of Appeals? I have to choose my words very carefully here. And this is why, as I was going through it, I'm like, wait a second, this is interesting. It's very rare. So no, okay, let me explain before I finish my statement. Listen very closely, chat. This is extremely important, okay? Pay very, very close attention to what I am saying because This is, okay. What is a show cause order or a show cause motion? Motion for order to show cause. Let's say I get a speeding ticket, okay? I'm driving too fast and I get a speeding ticket 10 miles over the speed limit. I go to court, I plead guilty, it goes on my record, and the judge gives me 14 days to pay my ticket. Now, let's say I don't have the money to pay my ticket right now, so I have 14 days. That 14-day date is going to be what's known as a show cause order. What does that mean? That means I have 14 days before I have to show cause as to why I need more time. Okay? That's a show cause. It's kind of like it's a weird legal term because it's part of a sentence. I am going to show up in 14 days time, and either I will have paid the ticket or I have to show cause. I need to show why the court needs to give me more time. Your Honor, I'm sorry. I've been working. I'm trying to make money. I have 15 children I'm taking care of. I need help. I'm not financially stable. Can you please give me more time? Okay. The court will give me 14 more days to pay my traffic ticket. Okay. That's a show cause order. That's a show cause date. We use that term very liberally. We use it all the time. Okay. That's show cause. So a motion for order to show cause, Doreen here, because this is Doreen's work, you see signed by Doreen, sent to Silverman as well, the opposing counsel. And it's, like I said, it's 2 pages, 1 page of text and the 1 page of the certificate of service. Final hearing has been set, date continued indefinitely. Good cause exists for you guys, the Court of Appeals of Florida, to issue a show cause order of the intolerable adversarial atmosphere Judge DeThomasis has engendered as set forth in the petition. So I believe they're also asking, remember you guys were telling me this? You guys were like, well, is he going to be off just this case for Jeremy, or is he going to be off all cases? This is what Jeremy's lawyers are asking in this show cause motion for show cause, motion for order, to show cause. Pursuant to Rule 9.100H, Jeremy Hales seeks a writ of prohibition prohibiting Judge Craig DeThomasis from further participating in Levy County Circuit Court, period. I believe this is a motion for an order for the Supremes to remove Judge DeThomasis from the bench. Holy shit. Hashtag buckle up. I almost missed this because I don't know how else to interpret this. Let's pull it up. 9.100H, because I want to read this. This is nice. 9.100 Florida Rules of Appellate Procedure. Florida Rules 9.00. This is going to tell it all. Let's see. Stop screen. So that was it. That was it for that one. But here we go. Now we're going to analyze what the rule means, because the rule is cited. Oops. Wait, wrong one. Sorry. Here we go. Share screen. There we go. There it is. H. Where's H? H. Okay. So this is 9.100. There it is. Florida Rule of Appellate Procedure 9.100. C, D, E, F, G, H. All right. Order to show cause. Order to show cause. If the petition for writ of prohibition demonstrates a preliminary basis for relief A departure from the essential requirements of law that will cause material injury for which there is no adequate remedy by appeal, or that review of final administrative action would not provide an adequate remedy, the court may issue an order either directing the respondent to show cause within the time set by the court why relief should not be granted, or directing the respondent to otherwise file within the time set by the court a response to that petition. In prohibition proceedings, the issuance of an order directing the respondent to show cause will stay further proceedings in the lower tribunal. Okay, it might just apply to Jeremy. Now that I read the rule, I think it applies just to Jeremy. I don't think it applies to the judge on the bench. But I could be wrong. Maybe my sources can help me out here because, again, this is something I don't have a personal experience with to this extent. I mean, I understand how these things work, but the actual, like, how does it work in practice? I understand it in theory, but I don't understand how it works in practice. In prohibition proceedings, the issuance of an order directing the respondent to show cause will stay for the proceedings in the lower tribunal. It may just be the show cause order is to basically freeze the proceedings. But I could be wrong. Maybe I can make a subsequent video on it when I do the subsequent video on Judge DeThomasis's absolute immunity and why he's doing what he's doing and how he's doing what he's doing, because he has absolute immunity. Okay. So that's basically where we're at. That's basically where we're at. But it could also be an allusion to, you know, I'm not going to put it past them to basically be like, look, I am, you know, Judge DeThomasis the Almighty, and the First District of Florida is going to look at it and go, you know what? We don't just want you to remove yourself from this case. We believe there is enough to remove you from the bench. Your behavior is egregious enough to where this one case has merited our decision to remove you. Look, the Court of Appeals has that power, probably. I mean, I know they have the power to remove him from this case, obviously, because a writ of prohibition otherwise wouldn't be filed. But maybe it can extend beyond that. I guess time will tell. Time will tell. We shall see, you know. Billy Joe Olson, thank you for joining on as a new member. Thank you very much. As well as the Beans, gifting 10. Shout out in the chat if you are one of the 10 who has received a membership. Thank you so much. Really appreciate your support. Green Dragon Zero, does US Code 242 make it a crime to deprive someone of their rights? I'm not familiar with that one specifically. US Code, I'm afraid to even search for that, because is it 18 USC 242? The provision makes it a crime for someone acting on the color of law to willfully deprive a person of a right or privilege protected by the Constitution. I don't know where this would be applied. I have zero experience with it. I'm sorry. I literally have zero experience with Title, not Title 18, but Title 18 Code 242. I have zero experience with. So I believe it's punishment of citizens. I don't think I don't think it applies to judges. Again, it would not apply to judges because they they enjoy absolute immunity. They enjoy absolute immunity. So I hope that answers that question, but that is a question that is completely outside my wheelhouse. Hashtag buckle up. Oh shit, crazy. Subisu, I love you. You're so funny. Jack's mom says they don't want him on his defamation case. Probably. So remove him completely from all cases related to them in Levy County. That's very possible. Sapphire Sky says the judge looks like Mr. Burns from The Simpsons. Dan Davis, hashtag the other shoe about to drop to remove the judge from the bench. So speaking of shoes, I need your all's help. I am embarrassed to say, I think I made a video on Sunday saying it is going to be national news by Friday, March 1st. Today is Friday, March 1st. It's already outside business hours here on the Eastern Seaboard. And I stated publicly, and I will hold myself to my words, that I will eat my shoes. Makes me hungry because I haven't had food yet. I will eat my shoes if this story does not go national news by mainstream media by the end of the week. So we still technically have about 5 hours. We still have about 5 hours. But I mean, what's the point of being held to your word if you're not going to um, honor what you have said? So I'm gonna make a video at some point of me eating my shoes. I have to. I don't have a choice. I don't have a choice anymore. So that's going to be a fun video. Not. I don't know. Am I going to fry it? Am I going to bake it? Am I gonna? I mean, I know. Like, all jokes aside, people do when there's hunger and starvation. I believe you can deep fry leather shoes, and they will actually be edible. But I did say I'm gonna eat my shoes if if this doesn't go national by the end of the week, and it hasn't, and I'm gonna live true to my word. So stay tuned for that. I'm gonna eat my shoes live on stream because this is the only way that I can maintain credibility. I did say that. I must live up to it. You're doing very well. Thank you, Debbie. I appreciate it. Sarah Dyson, also, thank you for the 5 gifted. Shout out in the description. Shout out in the chat if you have received a gifted membership. Thank you so much. Also, Dan Davis, Tubetown is blowing the story up around the world. Not surprised at all. Get a cake that is decorated as a shoe, LOL. Jesse, that's one idea for sure. We'll see what I come up with. There's a new Hales video. Has yesterday's court. Oh, no way. No way. Okay. Okay, what the Hales is, huh? What the Hales? Judge yells at me. Is that the one? Is that the corrupt judge? Oh my God. It's live. Or not live. It's posted, I should say. It's posted an hour ago. Go check it out. They're almost at 700,000 subscribers, you guys. Go subscribe to What the Hales is. And oh my God. Oh my God. I mean, hell, I would have. I would watch it on stream, but I don't want to deprive them of the views. So maybe I'll leave it for a couple days and then maybe I'll comment on it. But I want them to enjoy because they deserve the revenue. It's their stuff. Again, I'm just a lawyer with my own channel. Kate, cookies or cake shoes, please not. My attorney hates the taste of leather, says Henry. Hey, Henry. Good to see you, brother. Tubetown is coming. Tubetown is a coming. All right, y'all. All right, y'all. Let's go make a surprise. You guys ready? You guys are ready for this? This is a secret. Only a secret for the next 15 seconds. You guys ready for this? I wanted to thank you all for joining. There's 4,300 of you in here. We're going to pay Danny on direct a visit. You guys ready? We're going to raid her. Shout out in her chat, hashtag buckle up. Don't say anything else. Don't say we're here from DUI guy. Don't say anything. Just say hashtag buckle up. Spam her chat. She's going to love it. It's going to be funny. Just do it. Ready? 5, 4, 3, 2, 1.